So we're doing 9.
Nice to see you. How are you? Fine now?
Which one was Mr. Tell? No, but I mean, yeah. Okay, well, they asked me about voting rights on C-SPAN. I said, Mr. Tell. I said twice. Mr. Tell has asked 3 questions about. Well, see, the guy called me. No, it's a call-in program on C-SPAN. That was at 7:45 this morning. For the members who are present, except for the ones that are here already, it'll be on seniority, and then other people that come in, you'll be called on according to how our respective staffs keep track of you in the order of your appearance. Before Chairman Leahy and I give our opening statements, I'd like to go over some things I said yesterday. First of all, we welcome everybody back to this second day of hearing on Ms. Lynch's nomination to be Attorney General. As I said yesterday, and everybody abided by this, and I want to thank everybody that was here yesterday for their courtesy. I want everyone to be able to watch the hearing without obstruction, and if people stand up and block the view of those behind them or speak out of turn, it's not fair or considerable to the others. So officers would remove those individuals, and that's what I want to thank, because we didn't have any of those incidents yesterday. Before we begin the opening statements, take care of a couple housekeeping items and explain the process. First of all, I want to thank everyone for their patience yesterday. It looks like we're going to have more floor votes today. So again, I'm asking for your flexibility. After opening statements, the plan is to start the first round of questions, then recess so members can vote. We would then return after the first series of stacked votes, and I'm assuming that's going to be around 12:45, but you folks that are answering questions for us, you can't necessarily count on that. But then we would keep going through there's 4 votes this afternoon. We won't adjourn at that particular time. We'll do like we did yesterday. We will take time to, or take turns going and voting. Senator Leahy then and I will now give our opening statements. Then we'll turn to our witnesses for their opening statements. Following their statements, we'll begin with the first round of questions, in which each senator will have 10 minutes after the first round. Then we'll go to 8 minutes of questions. And so then I will give my opening statement. Obviously, welcome everybody, audience as well as witnesses, to our second day of hearings on Ms. Lynch's nomination to be Attorney General. Yesterday, we heard from the nominee. I thought she was very engaging, very competent. There's no question about her competence from what she's done as far as her legal background and her work as a U.S. Attorney. We appreciated her willingness to stay here through it all so we could get done with her in one day, and everybody that wanted to ask questions verbally could do it. Of course, there's going to be a lot of questions in writing for her to answer in time. She's clearly a skilled and competent lawyer. We asked questions yesterday, but I have to say, at least from my standpoint, I'm not speaking for any other member, it seemed like indirect answers. So I suspect that those will be followed up with questions for the record. Today we will hear this second panel in front of us right now. Many of these will speak to in many ways, the Department of Justice, under its current leadership, has failed to fulfill some of the most basic aspects of its mission. The question for me and a lot of members on this side is whether Ms. Lynch is committed leading the Department of Justice in a new direction. There's obviously people here that are going to speak about the direction of the department in a different way, and we'll listen courteously to that as well. We'll hear from Sharyl Attkisson as one example of a person who was an investigative journalist who's been bullied, threatened, and literally blocked from entering the Department of Justice because she had the guts to report on issues like Fast and Furious and Benghazi. That's one example of something we'd like to have a new Attorney General fix. We'll also hear from Catherine Engelbrecht, who was targeted by the IRS simply because she's a conservative who has had the courage to stand up in the defense of freedom and the Constitution. The department has paid lip service to the investigation that is supposedly leading. So I would like to know how Ms. Lynch will take seriously the targeting of fellow citizens based on their political views. Then we have Sheriff David Cook, Milwaukee, who will testify about how thousands of local law enforcement officers across this country feel as though the current leadership doesn't fully appreciate the work that law enforcement does every day. So that's important to see how Ms. Lynch might do to mend the broken relationships. And then we'll hear from Professors Turley and Rosenkrantz, who will address how the Department of Justice under Eric Holder has rubber-stamped the President's lawless actions from the unlawful recess appointments in the unlawful executive action, specifically on immigration. So those people will bring up points that we have made not quite as directly as they have, or personally as they have, in hopes that Ms. Lynch will restore the Office of Legal Counsel to the impartial role it used to play as a check on President's authority. So I look forward to the hearing today, and now it's Senator Leahy's turn to give his opening statement.
Well, thank you, Mr. Chairman. This is the second day of the committee's consideration of Loretta Lynch to serve as our nation's Attorney General. We had a long day yesterday. Today we'll hear testimony from outside witnesses about Ms. Lynch. I would especially be interested in testimony from those who actually know her. Yesterday we heard directly from her over nearly 8 hours of testimony. She testified about the values and independence she would bring to the office of the Attorney General. She testified how she would make as priorities national security and public safety, but still preserve the values that we Americans, I hope all of us, hold dear. I was encouraged when Republican senators on the committee agreed with me that the key question for voting for a nominee to be Attorney General is independence. Some of us remember past Attorney General who told us, well, he's a member of the President's staff. And we all had to remind him, no, he's not. He's not like the Secretary of Justice. He's the Attorney General of the United States and is supposed to be independent. Responding to questions on issue after issue, it is clear that Ms. Lynch is an independent lawyer of strong character, balanced demeanor, and obvious abilities. I also want to take a moment to thank Chairman Grassley for his handling of yesterday's hearing. It was no easy feat, especially when we had 18 votes, I believe it was, yesterday afternoon, and kept it going. He made sure that every senator who had a question on either side of the aisle, they were given the time to ask the question to be heard, and I commend him for that. I appreciate the tone of this hearing.
Thank you.
And today, but I was not surprised, the fairness that we've been friends for decades, and I know you well. We're going to hear from law enforcement officials who actually worked with Ms. Lynch. These are the people who have the best knowledge of her. They strongly support her nomination. Their presence today will speak to the support Ms. Lynch has among both Republicans and Democrats, similar to the letter that one of the finest FBI directors we've ever had has submitted on her behalf, Louis Freeh. Now, Barack Obama is not the nominee. That may come as a surprise to some who heard some of the questions. Eric Holder is not the nominee. Loretta Lynch, the daughter of Lorene and the Reverend Lorenzo Lynch, a U.S. attorney, twice unanimously confirmed by the United States Senate. One has been applauded for her law enforcement work. That's who's being called upon to consider. And I'm confident after hearing her testimony for the committee and after reviewing her record, no one in good faith could question her integrity or her ability. She said yesterday she looks forward to working with Congress to confront the many issues facing Americans today, and she's met with over 50 senators in both parties. So I hope we can come together in the Senate, support this historic confirmation of an outstanding public servant, and to move quickly doing it. Thank you.
Can I ask you, there's no reason to make these people stand for an oath, is there? Can't they do it sitting down? Sure. Or do they have to stand? Okay, I'd like to, well, I want to know what's
It's
legal.
okay with me.
Okay. Do you affirm that the testimony, would you raise your hand, please? Do you affirm that the testimony you're about to give before the committee will be the whole truth? No. Hey, let me start over again, please. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Now I'm going to introduce everybody at the table all at once instead of separately when one person gets done speaking, so be patient with me. Sharyl Attkisson is an investigative journalist and author. For over 20 years, she worked for CBS News, winning multiple Emmy Awards for her investigative journalism pieces, including her reporting on the 2012 Benghazi Report and Fast and Furious. Next, we have David Barlow. We know well. Mr. Barlow served as U.S. Attorney for the District of Utah, 2011-2014. Prior to his tenure as U.S. Attorney, Mr. Barlow served on this committee as Senator Lee's chief counsel. He's now a partner of Sidley Austin, Washington, D.C. Next is Reverend Newsom. Reverend Clarence Newsom is president of the National Underground Railroad Freedom Center in Cincinnati, Ohio. Next is Janice Fedarchek. Ms. Fedarchek served as assistant director in charge of FBI's New York Division 2010 to 2012. Ms. Fedarchek currently runs Fedarchek Consulting, Washington, D.C. I know I pronounced it wrong. Next, we have Stephen Legomsky, professor is at John S. Lehman University, professor at Washington University School of Law. Next, we have Jonathan Turley, is J.B. and Morris C. Shapiro, professor of public interest law, George Washington University Law School. David Clark, sheriff, Milwaukee County, and has served for over 36 years as a law enforcement professional. Next, Nicholas Rosencrantz is a professor of constitutional law and federal jurisdiction, Georgetown University Law Center, and a senior fellow at the Cato Institute. Finally, we have Catherine Engelbrecht. Ms. Engelbrecht is the founder and chairwoman of True the Vote, an election integrity organization, the founder of King Street Patriots, a citizen-led liberty group, and the co-owner of Engelbrecht Manufacturing, a small business she owns with her husband in her home state of Texas. Now we will start with Ms. Attkisson.
Thank you.
Oh, if I didn't, maybe I should say, I think you've all been informed, but we'd like to have 5 minutes.
Yes.
Okay, go ahead.
I've been a reporter for 30 years at CBS News. Yes, sir. Get a little closer. Can you hear me now? I've been a reporter for 30 years at CBS News, PBS, CNN, and in local news. My producers and I have probed countless political, corporate, charitable, financial stories ranging from Iraq contract waste and fraud under Bush to green energy waste under Obama to consumer stories relating to the drug industry. Some of these reports have been recognized for excellence in journalism, most recently Investigative Emmy nominations and awards for reporting on TARP, Benghazi, green energy spending, Fast and Furious, and a group of stories including an undercover investigation into Republican fundraising. The job of getting at the truth has never been more difficult. Facets of federal government have isolated themselves from the public they serve. They covet and withhold public information that we as citizens own. They bully and threaten access of journalists who do their jobs, news organizations that publish stories they don't like, and whistleblowers who dare to tell the truth. When I reported on factual contradictions in the administration's accounts regarding Fast and Furious, Pushback included a frenzied campaign with White House officials trying to chill the reporting by calling and emailing my superiors and colleagues, using surrogate bloggers to advance false claims. One White House official got so mad he angrily cussed me out. The Justice Department used its authority over building security to handpick reporters allowed to attend a Fast and Furious briefing, refusing to clear me into the public Justice Department building. Advocates had to file a lawsuit to obtain public information about Fast and Furious improperly withheld under executive privilege. Documents recently released show emails in which taxpayer-paid White House and Justice Department press officials complained that I was out of control and vowed to call my bosses to try to stop my reporting. Let me emphasize that my reporting was factually indisputable. Government officials weren't angry because I was doing my job poorly. They were panicked because I was doing my job well. Many journalists have provided their own accounts. The White House made good on its threat to punish C-SPAN after C-SPAN dared to defy a White House demand to delay airing a potentially embarrassing interview with the president. 50 news organizations, including CBS and the Washington Post, wrote the White House objecting to unprecedented restrictions on the press that raised constitutional concerns. A New York Times photographer likened the White House practices in some cases to the Soviet news agency TASS. Former Washington Post executive editor Len Downey called the Obama war on leaks by far the most aggressive he's seen since Nixon. David Sanger of the New York Times called this the most closed, control-freak administration he's ever covered. New York Times public editor Margaret Sullivan said, "It's the administration of unprecedented secrecy and unprecedented attacks on a free press." Months before we knew that the Justice Department had secretly seized AP phone records and surveilled Fox News' James Rosen, before Director of National Intelligence Director James Clapper incorrectly testified under oath that Americans weren't subject to mass data collection, I was tipped off that the government was likely secretly monitoring me due to my reporting. 3 forensics exams confirmed the intrusive long-term remote surveillance. That included keystroke monitoring, password capture, use of Skype to listen into audio and exfiltrate files, and more. Getting to the bottom of it hasn't been easy. It's unclear what, if anything, the FBI has done to investigate. The Justice Department has refused to answer simple, direct, written congressional questions about its knowledge of the case. It has stonewalled my Freedom of Information requests, first saying that it had no responsive documents, then admitting to 2,500 of them, but never providing any of them. In 2013, Reporters Without Borders downgraded America's standing in the global free press rankings, rating the Obama administration as worse than Bush's. It matters not that when caught, the government promises to dial back or that James Rosen gets an apology. The message has already been received. If you cross this administration with perfectly accurate reporting they don't like, you will be attacked and punished. You and your sources may be subjected to the kind of surveillance devised for enemies of the state. For much of history, the United States has held itself out as a model of freedom, democracy, and open, accountable government. Freedoms of expression and association are, of course, protected by the Constitution. Today, those freedoms are under assault due to government policies of secrecy, leak prevention, and officials' contact with the media, combined with large-scale surveillance programs. The nominee, if confirmed, should chart a new path and reject the damaging policies and practices that have been used by others in the past. If we aren't brave enough to confront these concerns, it could do serious long-term damage to a supposedly free press. Thank you.
If I'm accurate, Professor Rosencrantz, and you have recently had a back operation and you need to stand, we would not object, so whatever you have to do. Now, Mr. Barlow.
And I would echo that. Sitting here with recovering from 2 fractured vertebrae, I know how important it is to be able to stand.
Yeah. Okay. Mr. Barlow.
Thank you, Chairman Grassley, Ranking Member Leahy, members of the Judiciary Committee. It is my privilege to appear before you here today in support of the nomination of my former colleague, Loretta Lynch, to serve as Attorney General of the United States. I would be remiss if I did not first thank this committee for the strong support I received in 2011 when my own nomination to serve as United States Attorney was before you. It was a tremendous honor to serve as U.S. Attorney in the Department of Justice. I always will be grateful for the trust that you reposed in me when you supported my nomination. And it's now my privilege to recommend Ms. Lynch to you. You already have heard and read much about her storied 30-year legal career. So instead of elaborating on her many credentials, I want to take just a few minutes to share a couple of personal observations about my former colleague. I first met Loretta at a conference of United States attorneys several months after I was sworn in. And what I remember most vividly about her was the way she handled a portion of the program where U.S. attorneys were asking questions of the Executive Office of United States Attorneys. Loretta moderated the session. Some of the discussion regarding budgets, resource allocation, hiring authority, and other issues understandably became intense as my colleagues and I argued our various views and articulated the many needs that our districts had during lean budgetary times. But Loretta was calm and unruffled. She asked hard questions, but she did so in an unfailingly dignified and respectful way. Where strong feelings created the risk of bringing more heat than light to the conversation, Loretta brought only light. She was clearly tough, but also fair and gracious. Now, that impression of Loretta was confirmed and deepened as I served with her on the Attorney General's Advisory Committee, the AGAC. As you know, the AGAC is a committee of roughly a dozen United States attorneys who serve as a voice of their colleagues to the Department of Justice and provide counsel to department leadership on various management, policy, and operational issues. Loretta was the chair of the AGAC during the time that I served as a member of it. Now, I know that you already know that United States attorneys are not a timid group. All are accustomed to being in charge. All are used to expressing their views, and all are, at least in part, the products of very different backgrounds, experiences, and places. If you put 12 or so United States attorneys together in a room, as the AGAC does, you will get a wide variety of ideas and perspectives, often very strongly held. It takes someone very special to lead that kind of group. For the AGAC to work well, to work as it's intended, that someone needs to be smart, insightful, organized, articulate, inclusive, and experienced. Loretta was and is all those things and more. She was always well prepared. She made sure that all points of view were fairly and fully considered. She listened far more than she talked. She facilitated consensus wherever possible and made space for dissent when consensus could not be reached. And by her example and her conduct, she elevated the discourse and refined the exchange of ideas in our committee. Through these experiences, my initial impressions of Loretta Lynch were fully confirmed. She's tough, fair, gracious, smart, and independent. In conclusion, during my time as United States Attorney, I had the privilege of serving with a truly outstanding group of U.S. attorneys throughout the nation. I learned much from them. I was inspired by their service and their commitment. But of all these dedicated and talented public servants, the Honorable Loretta Lynch truly stood out. If confirmed by the Senate, I am sure she will make an excellent Attorney General of the United States. Thank you.
To Reverend Newsom.
Mr. Chairman and Mr. Ranking Member and members of the Judiciary Committee, it is my pleasure and honor to appear before you to support the nomination of Attorney Loretta Elizabeth Lynch for the position of United States Attorney General. I have known Loretta virtually all of her life. Our family relationships cover a period of 40 or more years. Her family has been associated with several branches of my family by way of the Baptist Church connection and the network of educators in the great state of North Carolina. Her grandfather was a highly regarded and respected clergyman. The same can be said of her father and her brother, both of whom have been distinguished leaders at the state and the national level for some time. For many years, her father was a key leader in the life of the General Baptist State Convention of North Carolina and the National Baptist Convention USA. Her brother continues in that tradition of leadership even now. Her father and I have been ministerial colleagues. We have been ministerial colleagues since the 1970s. It was my privilege to teach her brother during the years that I served on the Duke Divinity School faculty. I have been able to maintain a warm personal association with her mother, an esteemed church leader and educator in her own right, for decades. Through her father, brother, and mother, and mutual family friends, I have been able to stay abreast of Loretta's impressive and remarkable rise to a position of preeminent leadership in the life of our nation. Loretta is the product of one of the most outstanding families in the state of North Carolina. To the degree that virtue counts in our society, I am bold to say that she is the product of one of the most outstanding families in the United States of America. The members of the Lynch family are known for their exemplary character, integrity, excellent achievement, civic-mindedness, commitment to the common good, and deep and compelling sensitivity to the well-being of all people. Over the years, it has been my privilege to witness the development and emergence of the best of who we are as a nation in the person of Loretta. In the religious, educational, and social circles in which our families have moved, she has had a reputation for being stellar in everything she has done. As a teenager, she drew the admiration of adults, and more significantly, her peers as well. She stood out among them without alienating herself from them. She stood out in many, many ways. She was as approachable then as she is now. Even then, she enjoyed a reputation for being level-headed, balanced in her thinking, and wise in her judgments. She evidenced a level of maturity that was out of the ordinary, but only in those ways that garner the respect of young and old alike. As a teenager, Loretta was the daughter every parent would love to have. Early in life, the quality of her character was evident, and this is why the cities of Greensboro, where she was born, and Durham, where she graduated from high school with valedictory honors, claims her as a daughter who has made them proud. All the more proud we North Carolinians will be if she is appointed the first U.S. Attorney General in the state's history. As a student during her pre-college years, she performed at such a high level that it only seemed natural that she would attend and graduate from Harvard University and Harvard Law School. In fact, her career trajectory is consistent with the extraordinary intellectual ability and prowess, discipline, and even courage she demonstrated during her youth. Early on, she dared to dream to become the best of the best, and she has accomplished this in the field of law and jurisprudence. As her professional record shows, she has become the best of the best without qualification. In the way that her career has taken shape, I can discern several attributes that are worth noting at a time such as this. First of all, she is an informed, independent thinker who listens well and studies hard. Second, she has the capacity to maintain the strength of her own convictions. Third, she is morally grounded and principled, highly principled. Fourth, she acts decisively and judiciously. And fifth, she is a public servant of the highest order, the type that works well with others to bring about good results with positive outcomes. Thank you very, very much.
Ms. Fedarchek.
Chairman Grassley, Ranking Member Leahy, and members of the committee, it's my pleasure to appear before you this morning to speak about my association with the Attorney General nominee, Loretta Lynch. I wholeheartedly endorse her confirmation from the vantage point of someone who worked closely alongside Loretta in her role as the United States Attorney of the Eastern District of New York during my 2 years as the Assistant Director in charge of the FBI's New York office. I served in that capacity for 2 years, retiring in 2012 after 25 years of service in the FBI. As the Assistant Director in charge, I was responsible for the largest field office in the FBI, and inherent to that are the most complex and sensitive investigations in all of this nation's law enforcement. New York was and will remain the target for the terrorism activities of individuals and groups that espouse their violent agenda. From World Trade Center 1 in 1993 to the terrorist attacks of 9/11 and beyond, we continue to see this terrorist agenda manifested against New York. As a result, the FBI's resources and the considerable talents of the United States attorneys in both the Eastern and Southern districts of New York are almost in a daily undertaking to protect this nation's security. I think it's also important that the committee appreciate the magnitude of the criminal violations the New York office worked. These violations range from the complicated and pervasive financial crimes, the insidious and debilitating effects of organized crime and public corruption, and the violence associated with national gangs and other violent offenders. Given this challenging environment, it was a necessity to establish a substantial and seamless partnership with Loretta and her office. Over the course of the next 2 years, we formed an effective partnership to address not only the national security and criminal threats, but also to engage in outreach and liaison to make a positive impact in the community. The basis for my unquestioned support for Loretta's nomination is founded upon the numerous successes our office has achieved, the close professional and personal relationship that provided me extraordinary insight into Loretta both as a United States attorney and as a person. I was privileged to observe her commitment to mission, her personal involvement in issues that invariably arose in our work, as well as those within the broader law enforcement community. In supporting Loretta's nomination as the next Attorney General of the United States, I'd like to comment on 3 areas that form the foundation of my recommendation: sound judgment, legal acumen, and independence. In all of my interactions with Loretta, her approach to addressing and resolving issues invariably involved gathering information to understand the issue, obtaining input from affected stakeholders, and making a decision based upon the facts and the law. As you heard Ms. Lynch yesterday commit to a collaborative and deliberative approach, I can assure you, based on my experience, that she will follow through. While not an attorney, I do recognize that Loretta was nominated and confirmed twice as a United States Attorney in the Eastern District of New York, served on the Attorney General's Advisory Committee, and was named as the chair of the committee in 2013. And her favorable reviews by the Executive Office for United States Attorney, which called her exceptionally well qualified. Lastly, I've never known Loretta to make a decision based upon politics or outside influences. She consistently demonstrated fairness, respect for others, and a deep sense of duty. Under her leadership, her office embraced those qualities in their work. As I previously stated, our officers pursued a multitude of national security and criminal investigations, including the arrest of approximately 138 mafia figures that represented the largest single-day operation against the mafia in history. But other notable accomplishments span the spectrum of the national priorities and are example of her successes in the Eastern District, including international terrorism, public corruption, gang violations, violent offenders, etc. Ms. Lynch's recognition that task forces brought the best of interagency investigative resources to bear on entrenched crime problems was integral to broader and deeper successes than would have been the case for any one agency or department to achieve alone. These task forces included the nation's largest Joint Terrorism Task Force, the Violent Gang Task Forces, the Long Island Gang Task Force, the Healthcare Task Force, and the Financial Fraud Enforcement Task Force, to name just a few. In closing, Abraham Lincoln said, "Character is like a tree, and reputation like a shadow. The shadow is what we think of it, the tree is the real thing." Ms. Lynch is the real thing. Thank you.
Thank you very much. Now, Professor Leginsky.
Thank you, Mr. Chairman and honorable members of the committee. Thank you for the privilege of testifying this morning. I'm here to focus on the concerns that some have expressed about the President's recent executive actions on immigration. I do sincerely appreciate that reasonable minds can and do differ about the policy decision as to precisely what the enforcement priorities ought to be. But I want to respectfully share my opinion that the President's actions are clearly within his legal authority. That is not just my opinion. 135 immigration law professors and scholars signed a letter just this past November expressing that same view in strong terms. This is the mainstream view among those of us who have spent our careers teaching and researching immigration law. The President has not just one, but multiple sources of legal authority for these actions, and I've submitted a detailed written statement that documents each of these. The written statement also identifies every legal objection I could think of that the President's critics have offered, and it explains why, in my view, none of them can withstand scrutiny. So with limited time, I'll hit just a few key points and refer you, please, to the written statement for all the other points. First, I think all now agree that in a world of limited resources, prosecutorial discretion is unavoidable. You can't go after everyone, so you have to prioritize. In the case of immigration, Congress has made this explicit. It charged the Secretary of Homeland Security with, and I quote, establishing national immigration enforcement policies and priorities. That alone would seem to suffice, but in addition, year after year, Congress knowingly gives the administration only enough money to pursue less than 4% of the undocumented population. That, to me, is the clearest evidence possible that Congress intends for DHS to decide how those limited resources can be most effectively deployed. In fact, Congress has specifically required DHS to prioritize three things: national security, border security, and the removal of criminal offenders. And those are exactly the three priorities that these recent executive action memos incorporate. On top of all that, we have the 2012 Supreme Court decision in Arizona v. U.S., where the court struck down most of Arizona's immigration enforcement statute precisely because it would interfere with the federal government's immigration enforcement discretion, which the court went on at some length to emphasize the breadth of. Now, some critics claim that if the recent executive actions are legal, then that would mean there are no limits at all, and therefore some future president could suspend enforcement of some other law. But DACA and DAPA don't even approach the sort of hypothetical non-enforcement that argument conjures up. I think that if the president were to refuse to substantially spend the resources Congress has appropriated, then I believe we would have a serious legal issue. But that's not even close to the present reality, because even after DACA and DAPA are fully operational, the president still will have only enough resources to go after a small percentage. And so as long as he continues to use those enforcement resources that Congress has given him, it's hard for me to see how that could be called an abdication. As for deferred action specifically, the program has been around for more than 50 years. Not only has Congress never acted to prohibit it or even restrict it, Congress has affirmatively recognized it by name in several provisions. The formal agency regulations also recognize it by name. A long line of courts, including the Supreme Court, have recognized it by name. Not one of these legal authorities, not one, says or even intimates that it's legal if it's a small number of people, but otherwise not. The same is true for work permits. The statute authorizes DHS to grant permission to work, and the regulations specifically make deferred action recipients eligible for them. Now, some have said deferred action is okay on an individual basis, but not for a whole class. First of all, nothing in the law actually says that. And in fact, almost every modern president has granted reprieves from removal and work permits to large, specifically defined classes of undocumented immigrants. At any rate, the Secretary's November memo is filled with clear, careful, repeated instructions to officers that even if the general criteria in the memo are all satisfied, they still have to make individualized, case-by-case, discretionary judgments. And in fact, the very form that USCIS officers are required to use when they deny deferred action, and they've denied it more than 32,000 times on the merits, contains a list of the reasons, and one of those specific reasons listed is discretion. I think this is the way an agency should work. It articulates general criteria and then expects its officers to use some judgment in applying those criteria to individual cases. Thank you very much for your time.
Thank you, Chairman Grassley, Ranking Member Leahy, members of the Senate Judiciary Committee. I thank you for the honor of appearing before you at a historic moment in looking for the confirmation of the 83rd Attorney General of the United States. I want to begin by saying I have great respect for Ms. Lynch. As I've said before, her extraordinary career as a prosecutor pays great credit to her and to her nomination. Indeed, if confirmed, and I hope she is, I believe that she could be a truly great Attorney General. If great leaders are shaped at great moments in history, this could be such a moment for Loretta Lynch. The Justice Department is at the epicenter of a constitutional crisis, a crisis that consumed her predecessor and his department. My focus, therefore, of my written testimony and my oral testimony today is less on Ms. Lynch than on the department she wishes to lead. As my academic writings indicate, I've been concerned about the erosion of the lines of separation of powers for many years, and particularly the erosion of legislative authority of this body and of the House of Representatives. That concern has grown to alarm in the last few years under President Obama, someone that I voted for, someone with whom I happen to agree on many issues, including some of the issues involved in these controversies. We are watching a fundamental change in our constitutional system. It's changing in the very way that the framers warned us to avoid. The Justice Department has played a central and troubling role in those changes. In my view, Attorney General Holder has moved his department outside of the navigational beacons of the first and second articles of our Constitution. In that sense, Ms. Lynch could be inheriting a department that is floundering. The question is whether she can or will tack back to calmer constitutional waters. As discussed in my written testimony, the framers focused on one defining single danger in our system, and that is the aggrandizement of power in any one branch or in anyone's hands. They sought to deny every branch the power to govern alone. Our system requires consent and compromise. It goes without saying that when we are politically divided as a nation, as we are today, less things get done. But that division is no license to go it alone, as the President has suggested. You have only two choices in the Madisonian system. You can either seek to convince your adversaries or you can seek to replace them. You don't get to go it alone, and there is nothing noble about circumventing the United States Congress, because it means you're circumventing the United States Constitution. And any person who claims that they can get the job done alone is giving the very siren's call that the framers warned us against, and one that I hope this body resists. In my testimony, I've laid out examples of how this change is occurring. I've divided it between obstruction of legislative authority and the usurpation of legislative authority. The obstruction of legislative authority includes the blocking of the contempt citation, the non-defense of federal statutes. Usurpation includes many of the legislative changes that we will be talking about today and has been discussed by others. The American people, in my view, have been poorly served in recent years by the Justice Department. The balance that has been sought in recent years has been lost, precisely as the framers have feared. The rise of a dominant executive within our system, a type of Uber presidency. It is certainly true that the framers expected much from us, but no more than they demanded from themselves. They expected this institution to fight jealously over its own authority. They gave you that authority not to protect your power. The separation of powers is designed to protect liberty from the concentration of power. It doesn't matter what party we're from, and it doesn't matter if we agree with what the President has done. In my view, he has worthy ends, but he has chosen unworthy means under the Constitution, and the Justice Department has been a catalyst for that. In exercising the power of confirmation, this body has an undeniable interest in confirming that a nominee will address these relational breaches, these unconstitutional actions. I can only imagine the pride that Ms. Lynch's family will have when she raises her hand to take the oath of office. When that moment comes, however, there should be a clear understanding as to what she is swearing true faith and allegiance to as the 83rd Attorney General of the United States of America. The department that she leads should be the embodiment, not the enemy, of the separation of powers. It's a covenant of faith that we have with each other, and I sincerely hope that she regains that faith as she takes over, as she may, the Department of Justice.
Morning, Chairman Grassley and members of the Senate Judiciary Committee and Ranking Member Leahy. I'm honored to address you this morning about a frequent news topic, American policing at the local level. These hearings are focusing on the confirmation of possibly the next Attorney General of the United States, Ms. Loretta Lynch, and I wish her well. I want to spend some time critiquing outgoing Attorney General Eric Holder's tenure at the United States Department of Justice and use it as the framework as a way forward. The mission statement of the U.S. DOJ says to enforce the law and defend the interests of the United States according to the law. Let me repeat that. According to the law. To ensure public safety against threats foreign and domestic, to provide federal leadership in preventing and controlling crime, to seek just punishment for those guilty of unlawful behavior, and to ensure impartial administration of justice for all Americans. In my 36 years in law enforcement, I've viewed the United States Department of Justice as an ally in pursuit of justice. Local law enforcement has always been on the front lines in preventing and controlling crime and seeking just punishment for those guilty of unlawful behavior, as the mission statement of the DOJ implies. What I have witnessed from the Department of Justice under the leadership of Attorney General Eric Holder has been almost hostility toward local law enforcement. I've seen this in both public statements made about the profession and some of the policy decisions that treat police officers as adversaries instead of allies in the pursuit of justice. Partnering with local law enforcement agencies and ensuring the fair treatment of all Americans in the pursuit of justice are not mutually exclusive. What we all witnessed in Ferguson, Missouri back in August was a tragedy, an unfortunate incident for Officer Darren Wilson and citizen Mike Brown. What followed, however, compounded that tragic situation as people across the United States converged on Ferguson to exploit the situation for self-serving purposes. Suffice it to say that was not America's finest hour. In the days and weeks that followed in Ferguson, Missouri, the police-related use of force was forefront in the national news. What was called for at that moment when the U.S. DOJ inserted itself early into the process was an appeal to reasonableness, responsible rhetoric, and cautioning against a rush to judgment. Instead, some very powerful people made statements that only heightened rising tensions. Unfortunately, race is, has been, and will always be an explosive issue in America. The incendiary rhetoric used by Eric Holder created a pathway for a false narrative that then became the rallying cry for cop haters across America. It sparked unjustified hatred toward America's law enforcement agencies and its officers. Without a shred of evidence, a broad brush has been used to unfairly malign the reputation of the profession of policing in the United States. The accusation has been made that our community's finest systematically engage in the practice of targeting young black men because of the color of their skin. That claim is patently false, and I reject out of hand the mere suggestion of it. If I'm wrong, then someone needs to show me the evidence. Officers at the local level put on their uniforms and go out every day to make their communities better and safer with which to live. Without them, our communities would collapse into utter chaos. The world that our officers operate in is complex, dynamic, uncertain, and one where, unfortunately, things can and do go wrong. When that happens, the American law enforcement officer needs to know that after a thorough and transparent investigation, the facts and evidence of a particular case will be applied to the rule of law standard for a decision about their actions. After putting their lives on the line, they do not deserve a standard of false narratives, preconceptions, misconceptions, emotional rhetoric, or racial demagoguery. Author and scholar Thomas Sowell said in a thought-provoking piece on the rule of law, if police are told, who are told that they are under arrest and who refuse to come with the police cannot be forcibly taken into custody, then we do not have the rule of law when the law itself is downgraded to suggestions that no one has the power to enforce. So where do we go from here? How do we get beyond this damaged or frayed relationship between local policing and the U.S. DOJ? My suggestion is for the next U.S. Attorney General to articulate clearly a renewed commitment to rebuilding trust with local law enforcement. That involves open lines of communication with an emphasis on listening to the suggestion of law enforcement executives. And for the nation's sake, please stop undermining the character and integrity of the American law enforcement officer. Next, resist at the federal level to interfere with local police training standards. Are cops perfect? No, in fact, far from it, but they are our community's finest. Every community is unique in what will work and what will not work. We already have state standards for training. Finally, I want to speak on two emerging issues on the radar screen in criminal justice: sentencing and prison reform. Any discussion about reform in these two areas that does not include a counter view about the consequences of this short-term technical fix and its impact on crime victims will have a catastrophic consequence in an already stressed Black and Hispanic communities. The recidivist nature of criminals will cause more minorities to be victimized by violence, similar to what happened this past summer in Milwaukee to Sierra Guyton, a 10-year-old girl shot in the head and killed while on a school playground. The shooters were career criminals. The Black community does not have the support structures in place for an influx of career criminals sent back into the community or to deal with the habitual criminals who currently reign terror in neighborhoods. Adding more crime and violence to that mix will only bring more misery to the overwhelming number of decent Black law-abiding citizens just trying to get through life against already great odds. Reform that simply lowers the bar is nothing more than normalizing criminal behavior. Thank you very much.
Thank you, Mr. Chairman, Ranking Member Leahy, members of the committee. I thank you for the opportunity to testify at this momentous hearing. The committee has rightly decided to explore not just the qualifications of the nominee, but also the proper role of the office. I myself take no position on the ultimate question of whether the nominee should be confirmed. Rather, I offer some observations about the proper role of the Attorney General and some comments, alas, on the ways in which the current administration has fallen short of its constitutional obligations. You've explored at length the Attorney General's weighty responsibility to supervise the various components of the Department of Justice. But as you know, the most important responsibility of the Attorney General is not the supervision of the tens of thousands who work beneath her. It's the solemn counsel that she gives to the one who works above. Her most important job is giving sound legal advice to the President of the United States. And perhaps the most important dimension of this function is to advise the President on the scope of his executive powers and duties. The Attorney General should rightly explore all legal options for the President to achieve his goals, but at the end of the day, if no legal options are available, the Attorney General must be prepared to say, no, Mr. President, you have no constitutional power to do that. The fortitude, the rectitude required to say no to the President is perhaps the single most important job criterion for Attorney General of the United States. I'm afraid it's particularly important now in an administration that is inclined to press the outer bounds of executive power and to skirt the obligation to take care that the laws be faithfully executed. I hope the committee will thoroughly explore the nominee's conception of faithful execution of the laws and her resolve to advise the President when he runs afoul of this constitutional obligation. The Constitution provides that the President shall take care that the laws be faithfully executed. First, notice that this is not a grant of power, it is the imposition of a duty. The President shall take care. This is not optional, it's mandatory. Second, note that it is personal. Execution of the laws may be delegated, but the duty to take care that the laws be faithfully executed is the President's alone. Third, notice that the President is not required to take care that the laws be completely executed. That would be impossible. But so the President does have power to make enforcement choices, but he must make them faithfully. And finally, it's important to remember the historical context of the clause. English kings claimed the power to suspend laws unilaterally. The framers rejected this practice. With these principles in mind, we can turn to three recent examples. Alas, there are many more one could choose. First, the Obamacare suspension. So on July 2nd, 2013, just before the long weekend, the Obama administration announced that the President would unilaterally suspend the employer mandate of Obamacare, notwithstanding the unambiguous command of the law. The statute is perfectly clear. It provides that these provisions become effective on January 1st, 2014. This blog post, written under the breezy Orwellian title, "Continuing to Implement the ACA in a Careful, Thoughtful Manner," makes no mention of this deadline. Now, whatever it may mean to take care that the laws be faithfully executed, it simply cannot mean declining to execute a law at all. Our second example, immigration, is almost an exact mirror of the first. In this context, rather than declining to comply with a duly enacted statute, the president has decided to comply meticulously, but with a bill that never became law. So Congress repeatedly considered a statute called the DREAM Act, which would have exempted a broad category of aliens from the INA, but Congress declined to pass it. So on June 15th, 2012, the president announced he would simply not enforce the INA against the precise category of aliens described in the DREAM Act. He announced in effect that he would act as though the DREAM Act had been enacted into law, though it had not. Now, this is clearly not an effort to conserve resources. After all, the Solicitor General went to the Supreme Court to forbid Arizona from helping to enforce the INA. Exempting more than 1.76 million people from the immigration laws goes far beyond any traditional conception of prosecutorial discretion. Now, Professor Legomsky cited an unsurprising consensus of liberal immigration law professors approving the most recent action. I'll cite just one authority, the President of the United States, just a few years ago, quote, "America is a nation of laws, which means I, as the president, am obligated to enforce the law. With respect to the notion that I can just suspend deportations through executive order, that's just not the case. Because there are laws on the books that Congress has passed, there are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system, that for me to simply, through executive order, ignore these congressional mandates would not conform with my appropriate role as president." I would hope that the nominee would agree with this statement. My final example is IRS targeting, but I believe the witness to my left is going to talk about that. I'd be happy to answer constitutional questions on that topic as well. Thank you.
Good morning, Mr. Chairman, members of the committee. I am the founder of True the Vote, a national nonprofit initiative to protect voters' rights and promote election integrity. I'm here today because I was targeted by this government for daring to speak out. I'm one of the thousands of Americans who have become, sadly, living examples of this kind of trickle-down tyranny that is actively endorsed by the current administration and rigorously enforced by the Department of Justice. Over these past few years, the Department of Justice has made their presence very well known in both my personal and professional life. Since filing for tax exemption with the IRS in 2010, my private businesses, my nonprofit organizations, and I personally have been subjected to more than 15 instances of audit, inquiry, or investigation by federal agencies, including the IRS, OSHA, ATF, and the FBI. All of these inquisitions began only after filing applications for tax exemption. There is no other remarkable event or rationale to explain how for decades I went unnoticed by the federal government, but now find myself on the receiving end of interagency coordination into and against all facets of my life. I shared that same timeline as a part of testimony given in February of 2014 at a hearing before the House Oversight and Government Reform Subcommittee. Time did not permit then, nor does it now, to give a full account of the cast of characters and confluence of events that fill a binder with over 800 pages worth of government subterfuge. But in one way or another, the Department of Justice has found its way into almost every aspect of my story. In my attorney's testimony at last year's House hearing, she spelled out for the committee why we believed that the Department of Justice investigation into the IRS targeting scandal was, in fact, a sham. Within hours of her filing, she received a phone call from the Department of Justice, now suddenly wanting to interview me. It was the first time we had been contacted, and approximately 9 months after the investigation had purportedly commenced. An arrangement was made with the Department of Justice Public Integrity Division, but we were then told that the Civil Rights Division would also be participating in my interview. Now, this is significant because at the time, that same Civil Rights Division was fighting against True the Vote in a courtroom back in Texas, trying to prevent us from becoming an intervening party for the state in voter ID litigation that the Department of Justice had brought against them. The DOJ told my attorney that unless I was willing to waive my rights and obligations to the involvement of the Civil Rights Division, that they would not interview me at all. And to date, they still have not. A handful of months later, we met the Department of Justice in court again, this time as they represented the Internal Revenue Service in a lawsuit through the vote filed against the IRS in 2013. The DOJ assured the judge that there was no more evidence that could be recovered from any of the hard drive crashes that had befallen IRS employees named in our suit. All of the contents from all of the hard drives was certainly and irrevocably lost. This purported dead end in discovery went on to become a factor in the judge's ultimate decision to dismiss our case. Yet just 1 month later, the Treasury Inspector General's investigation turned up an additional 2.5 million emails, of which 30,000 were lowest learners. Is there the will to ever get to the truth behind this nightmare of citizen targeting? For 6 years, the Department of Justice has operated as an increasingly rogue agency where preservation of personal liberties runs a distant second to preservation of political power. Will this new leadership be any different? As the leader of a voter rights organization, I was extremely disappointed to hear Mrs. Lynch comments in a speech she made in Los Angeles last February, when she said that voter ID laws were passed in the Deep South so that, and I quote, minority voters would be disenfranchised. And further, that she applauded DOJ's lawsuits filed against those states having ID programs and promised that those lawsuits would continue. 70% of Americans believe that showing photo identification in order to vote is a common sense safeguard to our electoral process. Should we count on continued resistance from a Department of Justice led by Loretta Lynch? In fact, the most significant voter disenfranchisement threat currently facing our country was made possible by the President's recent order of executive amnesty. States are not prepared to deal with the coming influx of illegal aliens wanting social service programs like Medicaid, welfare, and of course driver's licenses. Federal law requires that these programs offer voter registration opportunities, which is a wonderful thing for American citizens. But these programs were not designed to verify citizenship, leaving many states without the necessary firewalls to ensure that non-citizens do not end up as registered voters. And every vote cast by a non-citizen disenfranchises the vote of a citizen. We know Mr. Holder is a proponent of amnesty. Where will Ms. Lynch stand on the issue? In a 2009 speech, General Holder called America a nation of cowards. Well, if you remember nothing else from my comments, please remember this. I am not a coward, and I'm not a victim. I'm a messenger for all of those Americans who love our country, love our fellow countrymen, and pray for a better tomorrow. And I'm here to say our country right now is at a tipping point. We have replaced rule of law with moral relativism. We have replaced truth with political correctness. And in all of the double speak and double think, we have become increasingly unsteady about how we, the people, factor into a future left into the hands of our current leaders. So please be bold. Please choose wisely, because America is watching. Thank you.
And now Ms. Engelbrecht, I'm going to call in just a minute, or in just 30 seconds, I'm going to call on Chairman Leahy to ask the first questions, because he can't come back this afternoon. But would you go ahead, Senator Hatch? You said you wanted to say something.
I just want to mention to you, Ms. Engelbrecht, that we're thoroughly investigating this. The only reason we haven't issued a report so far is that, as you mentioned, there were 30,000 more emails finally discovered, and TIGTA, the investigative arm of IRS, has not yet released those to us, and we're going to have to go through those before we issue a final report. But you have my total sympathy for what you've gone through.
Thank you, Senator.
And he's speaking as chairman of the Finance Committee. Yeah. Senator Leahy.
Well, thank you, Mr. Chairman. I appreciate your courtesy. I'd ask consent I put in the record.
Without objection.
I just mentioned a number of letters. Former FBI Director Louis Freeh, whom we all know very well, is supportive of Loretta Lynch and Congressman John Lewis, a number of Justice Department officials, both the Bush administrations and various Democratic administrations, the FBI Agents Association. I won't list all of them, but they could all just be part of the record.
They will be, Senator Leahy.
We have 9 witnesses here today. Would those who oppose Loretta Lynch as FBI director, would they please raise their hand?
Attorney General.
I mean, as Attorney General, I'm sorry. I was thinking Louis Freeh. Those who oppose her as FBI, as Attorney General, would they please raise their hand? Let the record show no hands were raised. Ms. Fedorchuk, it's amazing your record. You started off as a beat cop in Nevada, joined the FBI, and 23 years later, you were heading up the FBI's largest field office. And like many here, I was briefed during that time of some of the investigations you had underway, especially in the terrorist area. I mean, they were remarkable in their complexities. You also dealt, as you said, with Loretta Lynch during that time. Do you believe that she has a temperament and the demeanor to be an Attorney General?
Senator, my 2 years exposure working alongside Loretta, and I say alongside because it was truly a seamless partnership, I think gives me a little bit of background and experience to be able to say that I firmly believe that Loretta Lynch possesses all of the necessary attributes that the nation should demand of an independent Attorney General. And I wholeheartedly support her nomination and confirmation.
You, I don't want to put words in your mouth, but you find that she would make independent judgments, independent judgments.
Yes, sir, and in fact, that was part of my opening statement, the fact that one of the 3 attributes that I wanted to touch upon was the fact that she operated independently, did not bow to outside influences, looked at the facts, looked at the issues. When she was confronted with an issue, she gathered input from stakeholders, solicited their input, took a look at the law, made sure that her decisions were wholly based on the facts and the law and independently arrived at.
Your career in law enforcement is a lot longer than my career in law enforcement, but I know during my years in law enforcement, what we wanted was independence, and I appreciate that. Mr. Barlow, nice to have you back here. Usually we'd see you in the other committee room. Do you believe that Loretta Lynch has the independence to stand up to others in the executive branch, including the president, if she feels she is in the right and has to stand up to do her job as Attorney General?
Yes, Senator, I do. In my experience working with her and working through any number of different issues, seeing her in a variety of different circumstances, I have always known her to be thoughtful, well-prepared, and someone who is interested in the facts and the law. I don't believe the president or anyone on this earth could get her to make a decision that she did not believe was right and had a firm basis in where her duty was at that moment.
In Louis Freeh's letter, he talks about she being part of the group that went to Italy for the funeral of one of the top mafia fighters, somebody that both Director Freeh and I had known, and it said that she was there with him on that because of her attitude about organized crime. So I've known her peripherally over the years and more since the nomination. But Dr. Newsom, you've known her longer than all the rest of us. Do you believe she'd stand up for what she believes is right, no matter who she might be getting pressure from, President, me, Senator Grassley, or you?
Use your mic, please.
Oh, usually.
Absolutely, Senator Leahy. She would demonstrate independence in the most constructive of ways. One of her greatest attributes, as has already been noted, is her ability to hold forth with the strength of her own convictions, having prepared herself thoroughly, thought through matters very, very comprehensively, having identified the issues in a way that she could communicate her position in a way that would garner nothing but the highest of respect.
I talked about yesterday about as a young law student being recruited by the then Attorney General of the United States to come to work for him. And I'd asked him whether he would stand up to the President of the United States if need be. He assured me he would. Later he did when he prosecuted a man who was essential to the election of the President as President. And when I asked him later about that, I said, Attorney General Robert Kennedy, what was the reaction? He said, I stayed away from family gatherings for a little while. And Professor Turley, many of us have seen you many, many times. The House Republicans have hired you to sue the administration in another area. And taxpayers will pay your fee. It was said that this could cost as much as $3 million. They're not paying you $3 million, are they?
I'm certainly open to that, Senator Leahy, but no one's offered me $3 million.
What is the hourly rate you do charge?
I think it's, the hourly rate set by the contract, not by me, I think is the top of 500, but I seem to recall that. But I want to correct something. I'm actually working not for the House Republicans, but for the House Representatives. They voted to approve the
It's a Republican
litigation.
vote. It was a partisan vote, as you know. Not to put spin it too closely, but do you get paid for your testimony here today?
Oh, no, of course not.
Good. Thank you. I thought I'd ask out of fairness to you. Actually, the question I asked first was probably the one that I appreciated the answer the most when no hands went up, and I hope we can move on. Many of you have questions about past operations of the Department of Justice. I have some disagreements with that, but I think we're talking about the remaining time of this administration, the Department of Justice, and frankly, as one American and as a former prosecutor and as the longest-serving member of the Senate, and one who's voted on a lot of attorneys general, both for the Republicans and Democrats, I feel very, very confident voting for Loretta Lynch as Attorney General. And again, I thank you, Mr. Chairman, for your courtesy. You bet.
I'm going to start out with Ms. Attkisson. In your testimony, you say, I don't know what's wrong with this microphone. Can somebody fix it? Let me do it this way. In your testimony, you say that you have a long career of investigative reporting. Different. Turn it off. I'm sure.
Are all of theirs off?
Okay. I'm sure you've dealt with pushback from powerful people before, but what makes the last few years different?
I defer somewhat to some of my colleagues that I quoted in my opening statement who said this was, in their experience, which is longer than mine, the most difficult administration they dealt with. Ann Compton, another correspondent, said this was the most closed president she's dealt with in 7 presidents she's covered. And I see it as a high point on a trajectory and a continuum, meaning every administration seems to be worse than the last. Although they come in promising openness and transparency, they seem to pick up where the last one left off. And there hasn't been as much pushback, I think, from Congress and the media in some cases to keep that balance, because of course the government tends to, for whatever reason, covet information, separate itself from the public, and treat itself kind of as one and apart. But we're supposed to help create a balance so it doesn't get out of whack. And I think we haven't done a very good job at that in the last couple of years. Additionally, this administration has employed very aggressive techniques that are available to it that were not available years ago, such as using social media and surrogate bloggers to put out false information, to controversialize any reporters who dare to do the normal oversight reporting that we've done on other administrations. And I think that's been somewhat successful.
You say in your testimony that you were once barred from attending a briefing in Justice Department. What reasons were you given?
A briefing was called on Fast and Furious, and I was sent over to the office, but Tracy Schmaller, the press officer, called back immediately and said, don't bother to come, that she wouldn't clear me in the building. Although I have press pass, I've been cleared, through the FBI to walk up to the President of the United States, but she was not going to clear me through building security. She didn't give a reason other than to just say they only wanted the normal beat reporters to attend. I can't tell you how improper that is, in my view, how improper it is that government officials who control public assets would misuse their authority to, in essence, handpick the reporters who get to cover the story, I think, in essence, the way they'd rather it be covered, and keep out, in some cases, more knowledgeable reporters who've been covering that particular issue. That had never happened to me before. I never tried to go there afterwards. It didn't happen to me afterwards. But I think that was a very important thing that, that was done, and I think it was very improper.
Do you think any of your colleagues and fellow journalists pulled punches because they thought they might be barred?
I don't personally know. I think the reporters on the ground do a great job, but I do know there are managers and editors, and I've spoken to executives from 3 networks who have given instances in which they've been specifically threatened with loss of some sort of access if the news organization takes a particular news course. So that threat of access is definitely felt.
My next question gets to the fact that we aren't here to talk about her qualifications. I don't think anybody questions that. But whether she can make changes in the Department of Justice. What do you think needs to be done to correct the chilling effect on the press over the last few years?
Sometimes I think it's more than just the physical steps that are taken. It's an action that's seen and a message that's perceived. Right now, regardless of steps that have been taken to mitigate damage that's been done, there's still a large distrust of the Justice Department and, in some cases, government in general. There are members of Congress and staff and whistleblowers and other journalists who commonly talk about the idea that they believe, whether it's true or not, that they believe they're being monitored on their phones or computers and/or computers. How you get past that suspicion that's been created by the actions that we've seen, it's going to be difficult. One very tangible thing that could be done, and I think needs to be done, and I won't belabor it, but it has to do with freedom of information law, which is pretty much pointless and senseless now in its application at the federal level. It does no good. It's been used instead of facilitate the timely release of public information. It's been used as a tool to obstruct and delay the release of public information. It's no good. If you even do go to court to get your public documents, that's at taxpayer expense. It still serves the purpose of delay that the bureaucracy wishes to serve. And at the end, even if they have to pay the plaintiff's fees, that's done with our tax dollars, and basically the federal agency gets rewarded for a job well done because they've been able to obscure and delay the release of these public documents. So that FOIA is extremely broken at the federal level.
You just described my last question, so you won't have to answer, but just to make clear, you felt your computer was hacked, you filed for information on it, and you still don't have an answer. Is that right?
That's right. The FBI, I think something like, I filed a request just in general for information 540 days ago. Responses due in something like 20 business days, but this is very typical of FOIA responses. I got a very partial, incomplete response last night to a FOIA request that I'd made with the Department of Justice Inspector General, which did not include the forensics that supposedly came along with some conclusions and summaries they made. So that will be a process that who knows if I'll ever get the documents I've been asking for months, but this is very typical, reporters will tell you, and citizens and consumers, of their efforts to try to obtain easily accessible public information or information that should be easily accessible.
Ms. Engelbrecht, May 2013, General Holder announced that he had ordered the Department of Justice to conduct a criminal investigation into the IRS for targeting conservatives. At the time, the Attorney General called the IRS practices, quote unquote, outrageous and unacceptable. When did the Department of Justice first reach out to you or your lawyer to learn the details of your ordeal?
We'd heard nothing from the Department of Justice right up until the day before we were to testify before the House subcommittee. My attorney and I were both prepared to testify. My attorney filed her testimony in which we were very critical of what had happened to that point, and it was not hours later that the Department of Justice called for the first time to ask to speak with us. So 9 months approximately.
Okay. So after 9 months, the General Holder ordered the investigation, reached out to you, and what prompted them to do so? Do you have any idea?
Now, I think it was that testimony that was filed that left no stone unturned about what we'd already experienced.
So let me get this straight. Attorney General Holder announces an investigation into the IRS's targeting of tax-exempt groups like yours, and 9 months later, it takes a congressional hearing for you to be contacted by the attorneys at the Department of Justice. You just said yes to that.
Yes, sir.
That's disgraceful. Well, to your knowledge, who did they talk to before they reached out to you?
Certainly, we saw all over the news that they were talking to Lois Lerner and others inside the department. I was in very regular contact with lots of other leaders of other organizations that had been targeted. To the best of my knowledge, no one has been contacted still by the Department of Justice.
Mr. Chairman, I would note that the Alabama Tea Party leader who was victimized has still not been investigated, even been interviewed, even though I directly asked the FBI director to do so a long time ago.
Then, so to date, you've not been interviewed by the FBI?
No, sir. They did ask about 9 months ago, but it was upon the contention that they would be allowed to have the Civil Rights Division in, and I was not willing to do that because the Civil Rights Division had already been on record opposing my organization.
Okay. Well, I don't blame you for declining to speak to the Department of Justice. If I had been subjected to 15 audits and inquiries from 4 different federal agencies in less than 3 years, I would only want to meet with a neutral and fair investigators, and certainly not a person who had been appointed to do this investigation who also had an outstanding record as President Obama's campaign donor. One final question. Has the Department of Justice, or anyone else for that matter, advised you why 4 powerful federal agencies descended on your doorstep?
No, sir, but I'd sure like to know.
Okay. I'm going to, I'm at a loss here. Let me check with my staff whether I call on Feinstein or Hatch first. Okay, Senator Hatch.
Well, thank you, Mr. Chairman. I really appreciate what you've gone through. I can't say much about it because of 6103 authority, but we are going to get to the bottom of it.
Thank you, sir.
We've already gotten quite a bit to the bottom of it. I'm going to come back for at least a few minutes to thank this panel of witnesses for contributing to the confirmation process regarding Ms. Lynch's nomination. I'm going to be a strong supporter of her nomination. And I believe she's not only qualified, but exceptionally well qualified, and a very good person to boot. I especially want to recognize David Barlow, who's here today, who served as a U.S. Attorney in my home state of Utah for 3 years, and before that worked on this committee as chief attorney for my companion here in the Senate, Senator Lee. Professor Turley, welcome back.
Thank you, Senator.
Judiciary Committee. Yesterday, I asked Ms. Lynch whether the Attorney General has a duty to defend the constitutionality of duly enacted laws if there are reasonable arguments to do so. You discussed this in your prepared statement, and I'd like your comment on one specific issue that I raised. Attorney General Holder did not decide never to defend the constitutionality of the Defense of Marriage Act, but to stop defending its constitutionality. His own Justice Department lawyers had already been making reasonable amendments defending DOMA, or this bill, and Mr. Holder decided to stop making them. And that is what made me say that he's abandoned his duty. Do you agree?
I agree. I thought that the decision was wrong. I happen to agree with the President. I was a critic of DOMA. But I thought that the abandonment of the defense of DOMA was inimical to the rule of law. I thought it violated a longstanding understanding with this body. You know, there's history here, as you know. You're a student of the Constitution, and you know that there's always been this tension between the Congress and the Justice Department as to who can be in court defending things of this kind. The Justice Department has always insisted they're the exclusive representative.
Had you been Attorney General, you would not have stopped that.
Oh, absolutely, and I would have defended that law.
Even though you didn't agree with DOMA.
That's right. What's really,
Marriage Act.
and what's also troubling is that there's no definition in the Attorney General's position as to when they will abandon a federal law. I happen to agree with the criticism of the law, but there were plenty of people with good faith arguments that it's constitutional, including people on the Supreme Court. And if this is the standard for abandoning a federal statute, I could see a president doing this in a host of different statutes.
You're right about that. I appreciate your comments. I'm also glad that your prepared statement discussed the controversy over recess appointments. The idea that a president has the authority to tell the Senate when it is in or out of this or that sort of recess is astounding, and I'm glad the Supreme Court unanimously rejected the administration's position on that matter. In yesterday's discussion of prosecutorial discretion, the administration's defenders repeatedly said that this is really only about wisely using limited resources. You refer in your statement to the, quote, ill-conceived litigation strategy of the Justice Department, unquote, defending this bizarre position on recess appointments. I wonder how many resources the department uses pursuing these extreme positions in court that, as I said yesterday, got shot down over and over again, some 20 times. Do you agree?
Absolutely. I testified before the litigation after the appointments were made, and I said that in my view, even though I thought very highly of the nominee, that the appointments were flagrantly unconstitutional. There are close questions in the Constitution, in my view. This wasn't one of them.
That's one of the reasons I admire you. I mean, you're wrong on so many things, but you stand up. You're right on a lot of things, too. I have a lot of respect for you. Professor Legonsky, your prepared statement refers to a November 2014 letter from immigration law scholars. It states that the President's action establishing the Deferred Action for Parental Accountability Program is, quote, within the legal authority of the executive branch of the United States, unquote. But didn't the Justice Department's own Office of Legal Counsel, in its opinion issued a week earlier, conclude that, quote, the proposed deferred action program for parents would not be a permissible exercise of enforcement discretion, unquote. Even OLC, the Office of Legal Counsel, which seems to be into advocacy rather than analysis these days, disagrees with these scholars on this issue.
Senator, the OLC memo distinguished between granting deferred action to those children who had arrived at an early age on the one hand, and in addition, granting it to the parents of U.S. citizens and lawful permanent residents, while at the same time suggesting that it might not be legal to extend deferred action to the parents of the DACA recipients themselves. And
all right.
I do personally disagree with that latter suggestion of OLC, but otherwise I thought the memo was very thoroughly and well articulated.
Okay, Sheriff Clark, I want to personally thank you for your advocacy and leadership for police people all over this country and coming here today and giving your testimony. As I observed the reactions to the incidents like that in Ferguson, Missouri, I too became concerned about this rhetoric and the broad brush picture that seemed to be developing about all law enforcement. We heard elected officials claim that police officers across the country were indiscriminately shooting black men, simply out of fear. Those incidents happened at the local level and involved local law enforcement. How much do you think that the Attorney General of the United States can affect the situation negatively or positively?
Thank you, Senator. A lot. The Attorney General of the United States is a big stage, and when he or she talks, people listen all across the country, and it gives the impression that that is the policy of the United States Department of Justice, and they have to choose their words carefully.
Well, thank you. Ms. Attkisson, I don't know what your politics are, but I admire you greatly. You're what an investigative reporter ought to be. And frankly, your testimony here today has been very profound, very strong, and it ought to wake up everybody up at the Justice Department and in the administration, and in all administrations, both this one and any in the future. So you're doing a great public service here and having the guts to stand up and take the positions that you have. I have a lot of admiration for you. Professor Rosencrantz, during the hearing yesterday, I acknowledged that prosecutorial discretion obviously involves enforcement or resource allocation decisions in individual cases. But I said, quote, applying that discretion across the board to entire categories of individuals has the same effect of changing the law itself, unquote. Do you agree with that?
Yes, I do, Senator. It's not a clear line that one can draw, but when you start to talk about exempting millions and millions of people from acts of Congress, this looks a lot more like legislation than just like enforcement discretion.
Professor Lugomsky offers the Supreme Court's decision in Arizona v. United States to justify using enforcement discretion in a categorical fashion. But the court's opinion uses the word individual more than a dozen times. For example, it discusses, quote, the power to bring criminal charges against individuals, unquote, and whether, quote, an officer has probable cause to believe that an individual is removable, unquote. In fact, one of the quotes from the court's opinion that Professor Lugomsky includes in his prepared statement says, quote, the equities of an individual case may turn on many factors, unquote. Does that decision support using discretion for individual enforcement decisions in a categorical way, which has the effect of changing the underlying statute itself?
I quite agree with you, Senator. I think the traditional conception of prosecutorial discretion has always been case by case.
Okay, your prepared statement says that the most important dimension of the Attorney General's function, quote, is to advise the President on the scope of his executive powers and duties, unquote. Does that function happen on a blank slate, or do the essential principles of our system of government actually counsel special attention to the limits of presidential power?
Quite right, Senator. I think the core of that responsibility is for the Department of Justice and the Attorney General in particular to think hard about the meaning of faithful execution of the laws and to counsel the president when he is close to the line of unfaithful execution.
In other words, is the Attorney General there to find some plausible theoretical justification for whatever the president wants to do, or is she there to enforce the real substantive limits on power that are necessary for all of our liberty?
The Attorney General should help the president to find legal ways to do what he wants to do, but at the end of the day, it's essential for the Attorney General to be able to say, no, Mr. President, that's something you cannot do.
My time is up.
Thanks very much, Mr. Chairman. I'm going to be very brief. This is really a hearing to discuss the qualifications of a nominee. In this case, a very distinguished, very exceptionally well-qualified nominee on virtually any area that one can state. I really don't want to see that diminished by a critique by various people of the administration. And to me, Loretta Lynch is an outstanding role model, not only for women, but for all of us in this arena, because as you can see, so much of this arena has become so partisan that here's the use of a hearing on the qualifications of a nominee to be used to criticized the administration in areas that Loretta Lynch had nothing to do with. I guess that's the coin of our realm here. But, I mean, I remember other nominations where if the issue was independence, where nominees fully admitted, and the ranking member mentioned this, that they were a wing of the staff to the president. So I think we have a very special nominee in front of us, very skilled, very determined, but most importantly, I think she's used her life so well to be that combination of what was said by one newspaper, a combination of velvet and steel, and to see the impact of that on the strong support that she has for all of us in this arena, I think is a kind of role model as how you, there are a lot of people that know how to separate everybody. There are very few people that know how to bring people together again and really develop a kind of consensus that can lead us forward. And because this institution is so split, the role of Loretta Lynch in this day and age, I don't think can be underestimated. So the fact that when Senator Leahy asked the question, and I forget how he put it, you know, which of you is in opposition to Loretta Lynch, no one raised their hand. And I think it's that way throughout the nation. I think we should get on with the business. We should see this woman confirmed as quick as possible. Thank you very much. That's my statement. Senator Whitehouse.
Before I start claiming my time, let me say where we stand in terms of what's going on here, because the chairman has just had to leave for a vote, and he has left me instructed that if Senator Lee arrives or if another Republican arrives at the conclusion of my time, then they will be recognized. But if no one else is here, then we will recess at that point until 1:00 p.m. Is that correct? Okay, good. Let me take my time to sort of review the bidding, where we are. No witness present today opposes Ms. Lynch as the nominee for Attorney General. Ms. Attkisson is here as a litigant against the United States with her lawyer sitting beside her. Her testimony never mentions the nominee. And I would ask, actually, unanimous consent that the redacted version of the IG report related to her claims, which she now has, be made a matter of record, which without objection it will be. Mr. Barlow supports the nominee enthusiastically. Reverend Newsom supports the nominee enthusiastically. Ms. Fedarchik, to use her phrase, wholeheartedly endorses the nominee. Professor Legomsky is here mostly to talk about immigration. His testimony does not make clear whether he does or does not support the nominee. May I ask you if you do?
I certainly do. Thank you for asking, Senator.
Very well. That is now clear. Mr. Turley says that his interest today is not to discuss Ms. Lynch as much as the department she wishes to lead. But he goes on to say that he has no reason to doubt the integrity and intentions of Ms. Lynch, who displays obvious leadership and strength of character. Sheriff Clark is here and wishes the nominee well. But he goes on in his testimony to say, I want to spend some time critiquing Eric Holder's tenure. Professor Rosencrantz takes no position on the nominee, but comments on the tenure of Eric Holder. Is that correct, Professor? And Ms. Engelbrecht, if I said that right? Ms. Engelbrecht is an advocate for voter identification laws who would like Ms. Lynch to agree that voter identification laws are not efforts to suppress voting, but but took no specific position on the nominee. Is that correct?
No specific position, sir. I have all the hope in the world that
Very
it'll work
good.
out.
So let me say two things. One, some many years ago, George Washington set for himself what he called his rules of civility and decent behavior. He wrote 110 rules of civility and decent behavior to help him guide his own conduct in upright and honorable ways. I think it was Rule 89 of those rules of civility and decent behavior that George Washington kept that said the following: "Speak not evil of the absent, for it is unjust." There are plenty of forums where the Attorney General would have an opportunity to defend himself. This is not one. There is no forum here, there is no opportunity here for Attorney General Holder to answer these various charges that have been made. I think that is fundamentally unjust, and I think it is frankly beneath the dignity of this committee at a time when we have a very significant and solemn charge before us to determine the fitness of a specific individual to be Attorney General of the United States, to launch a series of unanswerable attacks. I have no problem with the attacks. My problem is that choosing this forum for them, where the individual in question has no chance to answer, I think fails President Washington's test that one speak not evil of the absent, for it is unjust. With respect to the other issues, I think we will have plenty of time to ventilate those in other forums. I'm sure we'll have plenty of time to address immigration, address voter ID and voter suppression, address surveillance, address all of those things. But once again, in this forum, there's no opportunity for another side to be presented. And I regret that this hearing and this solemn occasion has been co-opted to that extent and turned into what appears to be a soundbite factory for Fox News and conspiracy theorists everywhere. We actually have a nominee in front of us. She appears by all measures to be a terrific person. I think we should get about the business of confirming her and get about the business of voting on her. And if people have this strength of view that Attorney General Holder is not a good leader of the Department of Justice, the very best way to act on that would be to confirm Ms. Lynch as quickly as possible. I happen to disagree with that view. I am proud of what Attorney General Holder has done, and I would once again reference that he did not inherit a Department of Justice that was in good order. The Office of Legal Counsel had written opinions that were so bad and so discreditable that even that administration was forced to withdraw them once they saw the light of day and received peer criticism. U.S. attorneys of Republican and Democratic persuasions and appointments alike rose in irritation and anger about the effort to manipulate the United States attorneys that exploded into a scandal. There was that rather creepy midnight assault on a sick attorney general in the hospital when White House lawyers came over to try to get his signature on a document. And thankfully, now FBI Director Comey put a stop to that nonsense. And ultimately, the Attorney General of the United States was forced to resign from that office. So stepping into that mess, and there were plenty of other features I could add, I think that Attorney General Holder is entitled to great credit for having put that department back on its feet. I understand that he made decisions that people disagree with. I, for one, believe that those decisions are within the bounds of legitimate debate. I'm not suggesting that my colleagues need to agree with them, but I think to personalize them so much as to say that it shows a moral or personal defect on his part reflects really more the narrowness of a specific ideology than any true judgment about the merit of a man who has served his country as a United States attorney, as the Deputy Attorney General, as a judge, and as Attorney General with what I consider to be great distinction. So with that, I will conclude my remarks. I see my friend and former Attorney General colleague, Senator Cornyn, here as well. So under the chairman's direction, as I yield my time, it will go, as I understand it, to Senator Cornyn. Okay, I yield my time.
Thank you. I would thank my colleague and who I work with on a number of important matters. We're working on some important prison reform legislation demonstrating that dysfunction has not taken over everything here in Washington, that we can actually work on things even though we have other differences. But I just have to disagree with him, and I guess he disagrees with himself, because while he criticized the criticism of Attorney General Holder, he seemed to recall with great clarity the problems with the Bush Justice Department that he, or at least the things he disagreed with. So, but that's the great thing about the United States Senate and about our great country, where all of us ought to be free to express our views without fear, certainly of government intimidation. And Ms. Engelbrecht, I'm glad to see you personally, but I find your testimony once again chilling, and I admire your courage. And it can't be easy for a citizen to fight their government with all the vast resources arrayed against you. And I just want to assure you, you are not alone. And Senator Hatch, who's chairman of the Finance Committee, which has jurisdiction over the Internal Revenue Service, he's an honorable man, and I know you can count on his commitment as well to get to the bottom of some of the matters that you referred to, with particular regard to the Internal Revenue Service. So thank you again for your courage and your willingness to stand up to and I would say also inspire a lot of Americans who feel like government's gotten too big and too intrusive and has crushing the spirit and the voice of a lot of individual citizens. So thank you for being here. And Ms. Attkisson, I have to tell you how much I'm chilled by what you have to say. When I was in college, I was a journalism student before I lapsed into the law and became a lawyer. But the idea that that you would be targeted and surveilled, intimidated, or attempt to intimidate you from doing your job, and I know you are a skewer of power on an equal opportunity basis. I could tell from some of your testimony, you're not picking sides, but you are trying to do your job, and it's repugnant to me that government should try to array its power against the freedom of the press to intimidate people like you, and I appreciate the fact you are not intimidated. And I told Senator Leahy, who I've partnered with on a number of freedom of information reforms, he and I are the Senate's odd couple when it comes to that, people who ideologically are bookends, but who agree in the public's right to know, and certainly we want to work with anybody who's got a good idea how we can make the system better. And so I'd welcome that opportunity. I just want to say that Ms. Lynch appears to be an outstanding example of the American dream, and somebody who's got a distinguished career as a United States attorney. The challenge is for her and for everybody who takes on a job as a member of the President's cabinet is you are no longer just a prosecutor. You are somebody who is responsible for implementing policies implementing policies of this president. And that has been the subject of a lot of discussion here today. And as I told Ms. Lynch privately, you've got two choices. You can take the job and implement the policies, or you can say, Mr. President, I think what you're trying to do is improper, even illegal, unconstitutional, and quit, or not take the job in the first place. I don't see any middle ground on any of that. And while I have the same reaction to Ms. Lynch's testimony that I had to Sarah Saldana's testimony, who was a United States attorney from Dallas, Texas, who Senator Kay Hutchison and I recommended to the President for appointment, who's now the Director of Immigration and Customs Enforcement. I told her the same thing. You were a prosecutor, you've done an outstanding job, but now you're going to be in a policy position where you're going to be asked to implement policies that I disagree with, and you may in fact disagree with. So you'll be left with that Hobson's choice. So while I hear some of my colleagues talk about the independence of the Attorney General, well, it's perhaps some independence, but it really is the independence of one's personal conviction not to cross that line and to be able to tell even somebody as powerful as the President of the United States no when he's gone too far. Professor Rosenkranz, I'd be interested in your views on whether you think the Attorney General can truly be independent.
Well, I don't think independence is quite the right word. The executive power is all vested in the president, and that's as it should be, but the president has delegated to the Attorney General the function of advising him on legal issues, and that gets delegated again to the Office of Legal Counsel. And it's crucial for that function to be performed with as much integrity and independence as possible. At the end of the day, the president can disagree with the Attorney General, can overrule the Attorney General, can even fire the Attorney General, but it's essential for the Attorney General to say no if necessary, to say, Mr. President, I've explored every legal option and this is something you cannot do. This violates the Constitution.
Mm-hmm. Professor Turley, I know that Senator Grassley asked you questions about your representation of the United States House of Representatives in a lawsuit. As you probably know, there's also a lawsuit pending in Brownsville, Texas, brought by 26 different states challenging the President's executive action that we've been discussing here this morning. And obviously, any lawsuit that is brought, the plaintiff has to establish standing to sue, a claim of harm to them and not to the public generally. I remember that much of my law school lesson. But my point is, the policies of the federal government have a direct and very negative impact on state and local governments and on citizens who live, particularly in border states like mine, where just not that long ago, we had what the President himself called a humanitarian crisis. Tens of thousands of unaccompanied children coming from Central America, drawn by the magnet of a promise that if you can make it here, you're going to be able to stay here, something that a lot of people would like to do. So I'm not going to ask you to opine about the merits of that particular lawsuit. The judge there will probably make a decision here in the coming weeks. But do you see anything inappropriate about people who are aggrieved or suffering harm as a result of the actions by the President of the United States going to court and asking the court to make a decision?
No, I don't, but I've long been a critic of the current standing doctrines that have been developing over the years. I think Walter Dellinger put it best. We testified in the House recently together, and he said that he had spent his career as a standing hawk, and I've spent my career as a standing dove in that sense. I actually believe that it's important to give access to the courts, particularly for states, I think it's rather absurd to say that states have effectively no skin in the game, that they have no injury when you have these federal pronouncements essentially coming down and imposing considerable cost upon them. And I think that you really see it in sharp relief when these states have trouble even being heard on the merits. And so when we look at all of these cases in terms of the effort to keep the merits from being heard, I think that has a really dysfunctional effect. I think that's one of the reasons we're seeing so much chaos is the lack of definition in the separation of powers and these constitutional rules. That can be rectified if we give greater access in the courts.
Well, of course, from my perspective, coming from Texas, I see the policies of the federal government, particularly with regard to immigration, as having a very direct and real impact on taxpayers and citizens who are forced to pay the price in terms of health care, education, law enforcement, and the like, and they really have no recourse because they don't have the ability to do that for ourselves, something that is committed in the Constitution to the federal government's responsibility. And when the federal government doesn't do its job, the federal government doesn't necessarily feel those negative impacts. It's people who live in those places like Texas where it's very real. I want to just maybe ask one last question, and not to get too far down in the legalese, but Ms. Attkisson, as a result of the investigations that have been done here in Congress on the fast and furious gun walking debacle, we were met with a claim of executive privilege by the Attorney General that was then embraced by the President of the United States, even though there was no indication whatsoever that the President or high-level people at the White House were actually involved in this. But could you just describe the sort of obstacles that you ran into in the course of your investigation of the Fast and Furious scandal?
Well, some of this, which is already sort of in the public record, when I began covering the story, the Justice Department employees put out internal emails that said the story was false and the whistleblowers weren't telling the truth, which we now know it's been proven they were, and the Justice Department has admitted it. But they put out a series of false implications and information along the way. They launched a campaign, in my view, of calling superiors, bosses, colleagues, social media, using the bloggers that cooperate with them and work with them in some cases directly to disparage the reporting as if it were not true, repeating the false talking points in many cases. And it was, you know, an all-out effort to try to chill the reporting and to stop other reporters that might be pursuing it. You can see from internal emails that have recently been released after a lawsuit's been filed that were withheld under executive privilege, the extent of the lengths to which public affairs officials inside the government went to try to stop this line of reporting on a story that they clearly thought was proving to be very damaging for them.
Thank you. I'm advised that another roll call vote has been called on a series of votes that we're having in the, on the floor of the Senate. So at the request of the chairman, the committee will stand in recess until 1:30. Thank you.
Senator Sessions takes his turn, I want to thank everybody for understanding the chaotic way the Senate's run when we have all these votes and we have this important issue before us of who should be the next Attorney General. So thank you all for your flexibility, as well as my members. Before we turn back to questions, I want to take a moment to comment on some criticism that we heard this morning from one member on the Democratic side about some of the witnesses who are here today in this hearing. I won't speak for any other member of the committee, but I, for one, find it absolutely disgraceful how our government has treated some of our fellow citizens, and the Department of Justice under its current leadership has failed, really failed, to meet some of its most basic responsibilities. Every single one of these witnesses, every one of them, speaks directly to Mrs. Lynch's nomination, because the question in my mind is, as I stated yesterday, will she take these flaws seriously? Will she fix them? And I note that it wasn't too long ago that Democrats agreed that it was perfectly appropriate to call witnesses to address what they viewed as problems at the department. So I would note to the naysayer on the other side of the aisle, it wasn't beneath the dignity of the committee when they were in charge, so why would it be now? And I would make reference to Judge McCasey's hearing before he was approved to be Attorney General. The other side called witness after witness who testified regarding issues that occurred at the department while he was serving as a federal judge in the Southern District of New York. So, for instance, maybe it doesn't bother you that the IRS targeted conservatives and the department doesn't seem to have taken the issues seriously, but it bothers me a great deal. And I want to know if Ms. Lynch is committed to tackling this problem and a range of others. Senator Sessions.
Thank you, Mr. Chairman. And the Office of Attorney General is a big deal, and we need people who are able to take questions. The department is entitled to be criticized, and they're not perfect. And I love the Department of Justice. I served in it 15 years. I was an assistant United States attorney for over 2 and United States attorney for 12. And I loved that job, and I loved the people in it, and I so admired this department. And as I told Ms. Lynch in private conversation, you have to understand the reputation of this great department is being eroded. Situation is not good in this country. It's got to be reestablished. We're not going to allow this to become a political body that just conducts its work in haphazard political reactive ways. And I think Senator Hatch raised one of the questions that still galls me, and that is the failure to defend DOMA, the Defense of Marriage Act. That was a defensible act, and everybody that's ever been an attorney general or in such an office knows you have a duty to defend the laws passed by Congress. That's the attorney general's duty. Eric Holder and President Obama failed to do so, and it was shameful and disgraceful and an abandonment of the rule of law. And more people understand that. So I'm not happy about what's happened to my Department of Justice. Ms. Engelbeck, I think they should be investigating these matters. They haven't yet contacted people in Alabama, and I specifically requested it. Is this politics? Why not? Don't you go to the victims first? That's my experience, and get their story. Well, Professor Turley, I thank you for your comments on what's happening with regard to executive overreach and congressional weakness. I think it's I know we all, I don't deny that I'm a Republican conservative, but I believe this is not just a partisan matter. I mean, this is a huge erosion of constitutional powers of the United States Congress when the President of the United States, in contradiction to law, gives lawful status to people who are here unlawfully under the law. And not only that, creates a Social Security number for them, a photo ID, and an authorization to work, and a right to participate in Social Security and Medicare. I mean, this is a stunning event. And we are in denial here, a lot of people, about the seriousness of it. So I wanted to ask you about your testimony in the House. You say this, quote, the center of gravity is shifting, and that makes it unstable. You're talking about the separation of powers. And within that system, you have the rise of an Uber presidency. There could be no greater danger for individual liberty. And I really think that the framers would be horrified by that shift, because everything they've dedicated themselves to was creating this orbital balance, and we've lost it. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. And you go on and that's just a portion of your, I think, correct dissection of the fundamental issues at stake. Would you, I guess you stand by that, and do you have any further comments you'd like to make on that subject?
Well, I certainly do stand by it. The interesting thing about the Madisonian system that we have is that the three branches are effectively locked in an orbit like three bodies. In fact, the interesting thing about Madison is he was fascinated by Newton and the types of way that bodies would interact. And our system reflects that. And what happens is if you have a tripartite system that's based on a principle of balance, and then you introduce a dominant branch, it doesn't just fall out of kilter. It creates a very dangerous circumstance. There are many legitimate questions that come out of the Constitutional Convention, but the one thing that returns over and over again is the collective view of the framers, Federalists and Anti-Federalists, that the thing we have to fear most in this system is the rise of a concentration of power in one individual. And they knew a lot about it because they had just gotten rid of a person who had that type of concentrated power.
King George.
Exactly.
And I had the Congressional Research Service look at that, a matter of fact, and they concluded that King George III, at the time of the American Revolution, was unable to enact or repeal any laws without the approval of Parliament. And this was the heritage we had from the British, and that's what part of the Revolution was about. It's a fundamental principle in the formation of our government, that the executive does not get to make laws. Well, now, I appreciate that. Professor Rosencrantz, briefly, if you don't mind, do you agree with that, that we are at, I think Professor Turley once said, a tipping point in the question of executive and legislative power, and it's a matter of grave importance to the Republic?
I think it's certainly a matter of grave importance, and I think we have seen dramatic examples of executive overreach in the last several years, things that are unprecedented, things we've never seen before.
Well, and do you agree with Professor Turley that one of the most significant overreaches is the president's executive actions with regard to amnesty?
Yes, I absolutely do. I think it's inconsistent with his obligation to take care that the laws be faithfully executed, in particular the Immigration and Nationality Act.
Well, it seems to me that they're arguing that take care that the laws be executed means you have to do the best you can to enforce the laws under the circumstances, which has some legal basis. But in truth, don't they go well beyond that and create whole new laws that are not even on the books? They're not authorized to do that, are they?
You're quite right. This action looks a lot more like a legislative action than like executive discretion.
Senator, may I jump in and comment
Yes.
on that, please? Thank you. We've heard a lot of very broad general statements to the effect that separation of powers is important, which of course it is, that the president is not above the law, and of course he is not. But I've yet to hear any specific rebuttals to the points that I was making earlier about the specific sources of authority that Congress has provided. We do have this legislation which specifically says it is the responsibility of the Secretary of Homeland Security to establish, quote, national immigration enforcement policies and priorities. And not only that, but Congress has specifically directed the administration to prioritize three things: border security, national security, and the removal of criminal offenders. And those are precisely the priorities reflected in the recent executive actions.
Well, I appreciate that, but I don't agree. Congress laid out 500 pages of detailed law involving immigration. Many of them are mandatory, and they're not being followed. And we had yesterday, Professor Rosencrantz, I asked Ms. Lynch, who has more right to a job in this country? A lawful immigrant who's here, a citizen, or someone who entered the country unlawfully? And her answer, I believe that the right and obligation to work is one that's shared by everyone in the country, regardless of how they came here. And certainly if someone is here regardless of status, I would prefer they would be participating in the workplace. Do you think that contradicts immigration law of the United States?
Well, I do think this work authorization aspect of the President's action is perhaps the most troubling aspect of it. You know, the traditional view of prosecutorial discretion is inaction. It's the President deciding not to do something to someone. But this affirmative action of giving folks permits, that's something that's unheard of to traditional prosecutorial discretion.
I agree with that. As a prosecutor, I know what prosecutorial discretion is. Everybody that has to deal in the real world uses that on a case-by-case basis. And I further ask her, I want to have a clear answer to this question. Ms. Lynch, do you believe the executive action announced by the President on November 20th is legal and constitutional, yes or no? And Ms. Lynch said, as I've read the opinion, I believe it is, Senator. So we're being asked here to consider her nomination. Mr. Rosencrantz, when we decide who to vote for in the United States Senate to confirm somebody to the United States Congress, you think it would be improper for the voting body, the United States Senate, to consider whether or not we believe that person will be an advocate for and a supporter of laws we think are unconstitutional and offend the policies Congress has established? Should we consider that when we decide who to vote for?
I think it's absolutely the sort of thing that you should be considering, yes.
Well, I do too. And I believe Congress has a duty to defend its legitimate constitutional powers. It has several powers of its own. One of them is the power of the purse. One of them is the power of confirmations. I don't see any need for this Congress to confirm somebody to be the chief law enforcement officer of this nation who is at that table insisting that she intends to execute a policy that's contrary to law and to what Congress desires and what the American people desires, and says that someone here unlawfully is as much entitled to a job in this country as somebody here who's here lawfully. It's just beyond my comprehension. Are we through the looking glass? Can't we see plain fact? So everybody wants to talk about the politics. Well, the President can do this. He's shutting down Homeland Security, all these complaints. But the real question is fundamental. What are we going to do to defend our constitutional heritage? And what will this Congress be able to say to subsequent Congresses if we acquiesce in these kind of activities? I think it has permanent ramifications for the relationships of the branches of government. Mr. Chairman, you've got a meteoric rise there, I see. I'm impressed. But I got to say, no one could handle it better. I'm proud of you. I'm over my time. Thank you very much.
Thank you much, Senator Sessions, and thanks to all of you for joining us today. I deeply enjoyed your testimonies this morning before we had to go and vote. So thank you for being here. Thank you for sharing with us your opinions, which are helpful and informative. I want to begin my remarks just by commenting on some concerns that I've heard expressed from my colleagues on the other side of the aisle. Some have suggested that what we really ought to be doing here should be focused almost exclusively on Ms. Lynch's impeccable public service record and on the fact that she has served her country well, has served her clients well, that her resume is not just amazing, but that it's extraordinary, and it absolutely is. That we ought to be focused on those kinds of qualifications, and that we ought not be focused on the Department of Justice and on some of the things that are going wrong with it. I have a somewhat different view of that, in that I think both are relevant. For example, if we were running a company, if we were running a business, and we were looking for a new CEO, if we were looking perhaps more appropriately for a general counsel, we would probably want to know what someone's view of the organization as it existed might be. We would probably want to know whether that person acknowledged problems within the company, whether they were legal problems or other types of problems that the company faced. So I think we're kidding ourselves if we suggest that we shouldn't ask a nominee, someone who's been nominated to be the Attorney General of the United States, about problems existing within the U.S. Department of Justice. I think that's absolutely essential. And previous hearings in this committee have borne that out. Previous hearings in this committee where, for example, this committee reviewed Michael Mukasey after he was nominated to be the Attorney General of the United States in the last presidential administration. I think those hearings bore that out. Now, yesterday, we heard from Ms. Lynch. I'm very impressed with her legal abilities, with her analytical abilities, very impressed with her resume and her strong record of public service. I was, however, very disappointed yesterday in the fact that in response to many hypothetical questions that were asked of her, we didn't get a straightforward response, particularly when it comes to excesses of executive power, particularly when it came to questions about prosecutorial discretion and so forth. For those of you who may be watching this hearing who aren't burdened with a law degree, hypothetical questions are the bread and butter of the American legal education system. To a very significant degree, especially in appellate litigation, they are the bread and butter of the practice of law. One thing that I think all of us were taught in law school is that even when you don't want to answer a hypothetical question, even when it doesn't have an easy answer, you need to try to answer the question. If you don't, the judge will be very unhappy. I was disappointed yesterday that when I asked some questions of Ms. Lynch, she refused to give me a direct answer. In an attempt to try to elicit an answer from her, I made the hypothetical increasingly simpler, increasingly clearer, asking questions like the following. Imagine a hypothetical state in which there is a 55-mile-an-hour speed limit. Imagine that the public is crying out for relief from that law. There's pretty widespread agreement that the speed limit ought to go up at least to 65, maybe to 75, and that within the legislature, there is also widespread support for that. But the legislature can't agree on the exact speed limit to which it ought to be increased. So the governor, seeing an opportunity, then says, well, I'm just going to come out with a new policy. My policy is going to say if you want to exceed the 55-mile-an-hour speed limit, all you need to do is write to the governor's office, and I will send you back a permit that says for the next 3 years, while I'm the governor, I will not give you a ticket if you drive faster than 55 miles an hour, as long as you don't go faster than 75. And I asked Ms. Lynch, would that be appropriate? Would that be consistent with the rule of law? Would that be an appropriate exercise of prosecutorial discretion? I did not get what I perceived to be a direct one-word answer out of that, nor did I get a 5-word answer out of it. I didn't get an answer that I thought was satisfactory. What I did get was a response that said I'd really need to know more about that. But the more facts I added to the hypothetical, the more assumptions I added to it, it didn't seem to make a difference. So let me start by asking two of our professors that we've got here, Professor Turley and Professor Rosencrantz, Is that, in your opinion, a difficult hypothetical question, such that if a student in either of your classes refused to answer that hypothetical or said it was too hard, would that be an appropriate answer that you'd accept in your class?
No, I wouldn't accept it. I think that it is a straightforward question. I also think the question of whether or what the rule would be for the defense of federal statutes yesterday was also a question that should be able that someone should be able to answer. I also commend you, Senator, on your view of confirmation hearings. Too often people talk about these hearings as sort of job interviews where you just look at the credentials. These hearings have a very significant role for separation of powers. As agencies become more independent, this is the moment that Congress tends to get answers to questions, is when you're looking at someone who will head the agency. And as I've said in my academic writings, it's not often enough that senators use these hearings to try to rebalance or at least get answers from agencies, particularly one like the Department of Justice that has been so difficult to get material or answers from.
I appreciate your thoughtful response to that, and I want to get back to that in a moment. I've just been informed of an error. No sooner had I taken the temporary gavel in this committee hearing than I discovered that Senator Blumenthal was actually supposed to be next at bat. So my apologies for the error. We're going to pause on my questioning, and as soon as Senator Blumenthal is ready, we'll turn the floor over to him. Then we'll resume with me in a moment. Senator Blumenthal.
I really appreciate that, Mr. Chairman. And,
my apologies for the error.
Like our friend Senator Sessions, I applaud your meteoric rise within limits.
Thanks for the clarification.
But thank you for your courtesy and your deference. I'd like to ask Professor Legomsky to expand or explain a little bit why the examples involving enforcement of the speed limit may not be really an exact or valid comparison to what we have here.
Thank you, Senator. I think it's a fair hypothetical to throw out, but I definitely feel that there is no simple answer, mainly because there are two pieces of information we would certainly need. The big thing is that every statutory structure is different, and so the first thing I would want to know is, what does the state statute say? How much discretion does it actually give the executive branch to set highway safety priorities? In the case of the executive actions we're comparing it to, for example, again, as I mentioned earlier, Congress was very specific. It gave the Secretary the explicit authority to establish national priorities and policies, and in addition, even indicated what those policies and priorities are. In addition to that, the other point I would make is that it matters what the particular priorities are. They have to be rational in one way or another. I think most Americans, if asked, would say the president's priorities look like pretty much common sense to me. He's prioritizing national security, border security, and the removal of criminal offenders over the destruction of American families, the destruction of long-term community ties by people who have otherwise lived peaceful and productive lives in the United States. And since you can't do everything because the resources are limited, those strike me as reasonable priorities. So I would ask the same question with respect to the speed limits. Has the governor made a reasonable
maybe
choice?
the comparison would be more like the governor of Utah deciding that on a flat straightaway in the middle of the state, that going over the 65-mile-an-hour speed limit would not be enforced unless the person was doing something in addition dangerously, like weaving back and forth. But in more congested areas, that the 65 speed limit would be enforced rigorously. In other words, defining other characteristics, not just saying, we're not enforcing this law.
I think that's an excellent point, Senator, with all respect. And that is very analogous to what the president has done with his recent executive actions, because, as you know, both the prosecutorial discretion memo and the recent DAPA memo draw all kinds of fine gradations, and that, I think, accommodates the point that you were just making.
And just to clarify, there has been a suggestion that the president's exercise of discretion does not permit case-by-case decision-making. In other words, that it is a broad, across-the-board exception for all cases. But in fact, what the president's doing is really an exercise of of delegation of discretion, prosecutorial discretion, for case-by-case decision-making. Is that a fair characterization?
I think that's a very fair characterization. I'm thrilled to have the opportunity to answer that question because that's something that has concerned me a great deal about some of the criticisms that have been offered. The Secretary's memo says not once, not twice, but over and over again that officers on the ground are instructed to look at the facts of each individual case, to evaluate them on an individualized basis, and specifically to exercise their discretion. Not only that, but as I mentioned this morning, the form that the USCIS adjudicators are required to use when they deny a DACA case lists the possible reasons for denial, and it specifically lists exercise of discretion. There was one other thing I was going to mention, and that is that if anybody doubts that these instructions are actually being obeyed, more than 32,000 denials have already occurred on the merits. This doesn't count things that are rejected at the lockbox for failure to pay a fee. These are actual denials on the merits. And I must say, and I hope this doesn't sound snarky because I really don't mean it that way, that I worked at USCIS for 2 years, and I can assure everyone in this room that the USCIS adjudicators are not a core of open borders advocates who are looking for ways to systematically disobey the Secretary's explicit instructions. They take their job seriously, and they do exercise the discretion that the Secretary has told them to.
I appreciate that clarification. Of course, I would invite any of the other panel members to disagree if they wish to do so, but before my time expires, I'd just like to clarify a point that was made earlier by my colleague and friend, Senator Sessions. Loretta Lynch, I think yesterday, clarified that she does not believe there is a federal right to work for immigrants who are not in a lawful status. I believe that the record will show that she did clarify that point. And with that, if any of the other panelists want to comment on the question that I raised earlier, I would invite you to do so. And thank you for your explanation, Professor.
Well, Senator, I guess I'd just say I think the proof is going to be in the pudding, but people who have looked at this, the structure of the proposed policy, it appears that the case-by-case discretion that's built into this policy may well prove to be largely illusory.
And I think you have just really hit it on the head. You've just really hit it on the head, that the proof will be in the pudding as to what actually is done, as it is for every prosecutor, as a U.S. attorney, as a state attorney general. If I had decided I was not going to enforce any law, rightly, I would have been criticized. And the proof will be in the pudding in the same way as I had to make prosecutorial decisions, as every former prosecutor is a member of this panel, and at least one is here now. It will be in what the record shows. And we don't disagree if, in fact, the result is to make an across-the-board, wholesale, unexceptional rule. That would be wrong. Well, if the President decides as a matter of his discretion that across the board these laws are not going to be enforced, I agree with you. And when you say it's illusory, it will be, the proof will be in the pudding.
Well, Senator, I do think we can try to evaluate the proposed policy just on the terms of the proposal, and I think there's reason for skepticism even as the policy has been proposed. But you're quite right, the facts will develop on the ground.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Blumenthal. Okay, let's sort of pick up where we left off. I want to respond, first of all, to a couple of those points that I think are relevant. With respect to the straightaway in Utah, I mean, this is somewhat familiar to us. We have these salt flats in Utah where they take cars out that can go hundreds of miles an hour. I assume he means a straightaway on an actual state road. But there is a difference between deciding not to post a police officer there and issuing a permit saying you may exceed the speed limit. And if you're caught going up to 75 miles an hour, even though that's in excess of the lawful posted speed limit, you will not get a ticket. There is a distinction there. There is, moreover, the fact that another hypothetical question that I brought up that I was disappointed that she didn't agree to address head on was one involving a hypothetical future president. Maybe a Republican, maybe a Democrat, I don't know. Somebody who decides, you know what, I don't like our top marginal tax rates. And I think it's morally wrong to enforce a marginal tax rate above 25% at the top marginal rate. So I'm going to issue a series of letters to people who request them saying you can pay at the 25% rate and no higher and nothing's going to happen to you. I agree, moreover, Professor Legomsky, that something more like the answer that you provided would have been helpful. I didn't have even that, and had she provided that answer, we could have then gotten into a deeper discussion about whether or not Congress has in fact done this and whether or not Congress did in fact, based on an analysis of the text, create something that could create an exception to allow many, many millions out of the, I don't know, 11 or 12 million people who are estimated to be inside the United States illegally. Did Congress really create something that could create an exception that potentially swallows the rule or comes very, very close to it? Let's turn now to Professor Rosenkranz. You haven't had a chance to chime in on this issue. Tell me what you think about my hypotheticals. What would you do if somebody in your class refused to answer it?
Well, I was just going to say, Senator, I think your tax hypothetical is exactly right and indistinguishable from the current situation. I do not understand a principled way on which to distinguish those two cases. I would think a Republican president would be absolutely within his rights to cite this precedent and do as you suggest, if this were constitutional. I think it isn't.
Senator, I should clarify that we're more demanding at GW than at Georgetown in terms of how our students answer questions. So you have to put that into your consideration.
Good. Good. I hope you make that clear in your applications to law school, about how demanding you are. Everybody hates, especially in their first year of law school, to get called upon in class. Another point that I think deserves to be mentioned here is that within this framework, there has been discussion of the fact that there remains some discretion on the part of our immigration enforcement authorities in this country, even after the November memorandum, even after DACA and DAPA and so forth. That's different than the way prosecutorial discretion normally works. I mean, the way prosecutorial discretion normally works is that you say, we've got finite resources. I'm not going to prosecute everybody. We're going to sometimes not do it because perhaps we think the circumstances of the case don't trigger any kind of moral outrage, and we're just not going to go in that direction. There's also just the practical reality of the fact that you're not going to be able to get everybody. But that operates as an exception to the normal rule that if you break the law, you can expect that prosecution is at least some possibility. Whereas here, even to the extent you can say that there might be some discretion to decide not to enforce the law, they still make clear these presidential, these executive decisions still make relatively clear that they intend, as long as these criteria are satisfied, to not enforce the law, that they're not going to enforce the law. And they do issue documents saying you may work. And so I refuse to accept this as just an act of either ordinary garden variety prosecutorial discretion, and I also refuse to accept as an article of faith the fact that Congress would ever, or did, in fact, in this circumstance, give so much discretion to the President of the United States, to the Attorney General, to the Secretary of Homeland Security, so as to create a loophole that could swallow a very substantial chunk of the entire rule. This is not consistent with the way the Constitution of the United States has historically functioned. And getting back to how I opened, I do think that these are relevant questions. Yes, they are different in kind than the kinds of questions that deal with someone's resume or someone's professional qualifications, but we're looking here at a very specific kind of job. Someone who's taking the role as Attorney General of the United States. We've seen, we've heard testimony from several of you today that this is a department that has some real serious problems right now. Problems that really make the hair stand up on the back of my neck sometimes. And that was reiterated today with some of the testimony that I heard. And so I walked into that hearing yesterday wanting, hoping, frankly expecting to really like Ms. Lynch, and I do like her. And she met with me in my office before the hearing, and I liked her. I expected that I might be able to go either way on this, that I might well end up supporting her. I did not feel comfortable at the end of the day yesterday with the idea that I could vote for her because of the fact that I didn't get answers to questions that I find very troubling. And I found it a somewhat cavalier answer, a somewhat cavalier response to suggest that she needed more facts when some of these were very basic questions. I see my time's expired. Okay. And unless, do we have any Democrats here? On just making sure we didn't have anybody in the ante-room. I'm told that Senator Cruz is next at bat.
Thank you, Mr. Chairman. I want to thank each of the members of this panel, a very distinguished panel to come together and address some very important issues facing this country. I want to, at the outset, extend my apology that earlier in the hearing, the senator from Rhode Island characterized the testimony that we have heard from witnesses on this panel as, quote, conspiracy theories and sound bites for Fox News. I don't think that's an accurate characterization of the learned testimony that this panel of witnesses has given to this panel, and I apologize that you are subjected to having your character impugned by that, in that manner, by a United States Senator. I think this panel has focused on some very important issues that need to be highlighted. I would note that Ms. Engelbrecht is a constituent of mine and a friend. I have long thought highly of your commitment to public engagement, your volunteer efforts to make a difference in our political discourse. And I wanted to ask you, as a citizen who engaged in the political process, how did it make you feel to be targeted by the government for persecution?
It takes your breath away when you don't know quite where true north is, and it begs the bigger question, what is this country really, and where am I raising my children? Where is their safe harbor? And that's why I think that this panel and these questions that we're discussing here today are critical. We have to understand what we've just come through, that we're still in, if we know where we want to head. And I hope we want to head in a decidedly different direction.
You know, it was some decades ago that President Richard Nixon attempted to use the IRS to target his political enemies. He did not succeed in those attempts, but he was nonetheless roundly decried in a bipartisan manner. In this instance, the attempt sadly bore fruit. And it's been well over a year since the news broke. Let me ask you, Ms. Engelbrecht, do you feel in the over a year that's transpired, do you feel that the truth has been uncovered and that justice has been served?
Oh, no, absolutely not. Just the fact alone that I've still not been interviewed or met with, nor have any of the other groups that I know of that were part of this targeting scandal. How you can continue on under this ruse that that's ever going to arrive at any kind of conclusion is mystifying to me. And we seem to continue to find more and more evidence, and it continues to get further and further buried until I guess they hope people just forget. And that's why I keep showing up. I hope they don't forget.
You know, yesterday I asked Ms. Lynch if she thought it was appropriate to have the Department of Justice investigation into the IRS targeting and abuse of power led by a major Obama donor and Democratic donor who's given over $6,000 to President Obama and the Democratic Party. And she said she found nothing objectionable about that, and she flat out refused to appoint a special prosecutor, much as Eric Holder has refused to appoint a special prosecutor. I mean, let me ask you, as a citizen, do you have faith in the impartial administration of justice with an investigation being led by a major Democratic donor?
I take so much exception to that appointment and to the way that division has conducted itself that I, quite frankly, don't even know where to begin. Yes, I think that there's an awful lot wrong with it, and it's just sad that they're not held to account to explain their actions.
Senator, I might just mention the constitutional dimension of this particular scandal. So, discriminatory enforcement would have horrified the framers, and this kind of discrimination would have horrified them more than any other. Discrimination on the basis of politics. The single most corrosive thing that can happen in a democracy is for incumbents to use the levers of power to stifle their adversaries and to entrench themselves. It casts doubt on everything that follows. So it would have been their deepest concern constitutionally.
Well, thank you, Professor Rosencrantz, and I certainly agree with that observation. And I would note that discriminatory prosecution is often intended to have the effect, and in fact has the effect, of stifling further speech. And Ms. Engelbrecht, have you heard concerns of other citizen activists that perhaps they shouldn't speak out or get involved because they too might be targeted?
Absolutely. I mean, the IRS is arguably the most feared agency in possibly the world. And there are an awful lot of folks out there that just packed up their tent and stopped their little community organizations because they didn't want to be a party to what they saw unfolding.
You know, I have to say it was disappointing yesterday that Ms. Lynch also expressed no concern about the First Amendment rights of citizens, about the effect of the IRS targeting citizen speech, and about the effect of both bias and conflict of interest and the appearance of bias of conflict of interest on the impartial administration of justice. I want to shift to a different set of issues, which is the pattern of lawlessness of this administration. And I want to focus on a line of inquiry that we had yesterday with Ms. Lynch concerning prosecutorial discretion. And I want to address this question to Professor Turley. Let me say, Professor Turley, I commend you for having the courage to speak out about your concerns about the constitutional dimensions of the conduct of the executive. I recognize that has not been easy for you to speak out, and I suspect you have heard more than a little grief in the faculty lounge for having done so. So let me say thank you for having the courage of your convictions. I wish we saw a lot more members of this body with similar courage of convictions. Yesterday I asked Ms. Lynch if she agreed with the reasoning of the Office of Legal Counsel that under the theory of prosecutorial discretion, the administration could decline to enforce immigration laws against 4 to 5 million people in a categorical manner, and beyond that could affirmatively issue work authorizations, print documents that purport to authorize them to violate federal law and work in direct contravention to federal law. Ms. Lynch said that she found that OLC reasoning persuasive. Do you agree with that assessment?
I have serious problems with the reasoning for a couple of reasons of my own. First of all, much of what we do when we look at separation of powers is to look for limiting principles. We're in a system of government that is shared and limited in its nature. And part of the problem that I have with the administration's position on things like immigration is that it lacks that type of limiting principle. To respond to my colleague, who I have a great deal of respect for, I don't see this is a matter of discretion. First of all, I'm not too sure if it really does mean what my friend said, why they bothered even saying it, because that would make it just a standard prosecutorial discretion of people who are boots on the ground. I don't know why you would even issue this if it meant what my friend has said. But second, if you look at that letter from immigration faculty, as I did, once again, it raised this issue. What's the limiting principle? The letter seemed to suggest that as long as you're deporting one person, everything before that point is a matter of discretion. I can't believe that could possibly be true. If that were true, then virtually any law could be shut down except for one case, and you could claim you're just exercising discretion. I do criminal defense work when I'm not teaching, and I think if I went to a prosecutor and said, look, I'd like you to basically give my guy a walk because this whole category that he's a member of really shouldn't be subject to this type of enforcement, I think most would look at me like I had two heads. They certainly wouldn't give me much help on that. There is a legitimate question of prosecutorial discretion, but this is not one that I recognize. But my concern really as a constitutional scholar is if this is prosecutorial discretion, I don't know what would not be prosecutorial discretion. And this notion that is developed from prosecutors, is not obviously in the Constitution, would swallow the obligations of the president. Any discretion that my friend talked about in terms of setting policies and priorities has to be defined within the context given to the administration by Congress.
Well, Professor Turley, I very much agree, and my time is expiring, but I want to ask one final question, which is I agree with you that the question is where do you draw the line? If the president can, through discretion, simply refuse to enforce a major portion of immigration laws as it concerns millions of individuals, what other laws can the president unilaterally refuse to enforce? And yesterday I asked Ms. Lynch about a couple of examples. Number one, could a subsequent president instruct the Secretary of the Treasury, do not collect taxes in excess of 25%? And number two, I asked, could a subsequent president instruct the Department of Labor, you shall not enforce any of the federal labor laws on the books against the state of Texas. The state of Texas is hereby immune from every federal labor law that has ever been passed. To both of those hypotheticals, Ms. Lynch refused to answer, refused to say what I think is the obvious constitutional answer, which is, of course, a president cannot do that. And so the question I want to ask Professor Turley, and I want to give an opportunity for everyone in this panel, anyone on this panel who wants to engage, does anyone on this panel disagree that it would be unconstitutional for the president to refuse to enforce the tax laws or the labor laws or the environmental laws? And if you think that would be unconstitutional, does that not necessarily lead one to the conclusion that the president's executive amnesty is likewise unconstitutional? Professor Turley, if we could start with you.
Well, I believe those examples would be unconstitutional if the president claimed that authority.
I actually agree with both Senator Cruz and Senator Lee that there is a difference between saying we simply will refrain from prosecuting and saying we will give you deferred action and a work permit. But on the specific question that you've asked just now, I do think that a decision to not enforce the entire immigration laws or not enforce the entire tax laws would clearly exceed the president's legal authority. But that's not even close to what we have here. As I mentioned a moment ago, even after these new policies are fully operational, there will still remain in this country at least, and this is a conservative estimate, 6 to 7 million undocumented immigrants to whom these policies don't apply, and the president still will have only enough resources to go after fewer than 400,000 of them, which means that nothing in these policies will prevent the president from continuing to enforce the law to the full extent that the resources Congress has provided.
Let me briefly ask a clarification on your example. The reason you said the executive amnesty is constitutional is because there exists some substantial subset of people against whom the laws are enforced. Well, let's take the labor law example. If Texas were exempted, there'd be 49 states, a whole bunch of people you could enforce the labor laws against. So would that satisfy the test you've just put forth?
If I understood the hypothetical correctly...
Hang on just one second. In the interest of time, after he answers this one, we're going to have to turn to Senator Rankin. We've got votes coming up, so we've got to keep it moving. Thank you.
I'm sorry. I just want to make sure I understood the hypothetical correctly. In your hypothetical is the president enforcing the law in one state but not in the other states, or vice versa. One of the limitations, I think, is that the particular priorities have to be rational, and I think that discrimination against the residents of one state would fail that test. Along the similar lines, my friend, Mr. Turley, says that the law professor's letter was making the claim that as long as even one person is deported, then it's okay. There was no such claim in the letter, which I know very well. Yeah, there was certainly no implication in the letter that all you would have to do is deport one. The point the letter makes is that the president is fully spending all the enforcement resources that Congress has provided. But the president is not a magician. He can't spend resources he doesn't have. And that's why that example is very different from the ones that have been hypothesized.
Thank you very much.
Mr. Franken.
Thank you. I want to thank all the witnesses for being here today, for your testimony and your patience. I just want to talk to some of you who know Ms. Lynch. Mr. Barlow, thank you for your service to the Justice Department and for coming here today to speak on behalf of Ms. Lynch. As you know, the Attorney General must be both an excellent leader and an open-minded collaborator. The Attorney General must develop and coordinate policies among the various components of the Justice Department with other agencies. Based on your experience serving with Ms. Lynch on the Attorney General's Advisory Committee, how would you characterize her leadership style?
She's a leader among leaders, Senator. I would describe her style as being inclusive, thoughtful, careful, deliberative, and she's someone who is seeking consensus wherever it may be found. I've also seen her recognize that occasionally the consensus cannot be reached, and when it could not be reached, making sure that there was space for dissent so that all parts of the issue could be fully examined.
Thank you. Ms. Fedarchik, thank you for your service to the FBI and for being here today. You served with the FBI's New York office for 25 years, right? And have worked with many U.S. attorneys. In your testimony, you noted a wide range of cases that you worked on with Ms. Lynch, and the window that this gave you into her legal acumen, her leadership style, her character. How would you rate Ms. Lynch's performance as U.S. Attorney, and could you just elaborate on the skills that you have observed that would speak to her ability to serve in the role of Attorney General?
Thank you, Senator. And just by way of clarification, I was in New York for 2 years before I retired, and during those 2 years had the opportunity to work with Loretta in her capacity as the United States Attorney.
Oh, sorry.
We undertook any range of significant and complex investigations, ranging from national security through the complex financial frauds, all the way through the panoply of the criminal violations that include violent gangs and other types of violent offenders. I had a very close opportunity to observe Loretta during the course of these investigations, but also beyond the conduct of making decisions about cases and timelines for takedowns and the operational considerations, although those were extraordinarily important, clearly, because the symbiotic relationship is such that the New York office, and I would argue the FBI writ large, cannot do its job without that kind of symbiotic relationships with the U.S. attorneys. So my observation of Loretta in that role was that she led from the front. She instilled qualities within her office, gave them the resources, the opportunities to take on and grow themselves as leaders within the office. But she was not afraid to become intimately involved because she wanted to know what was going on with the cases and not to micromanage. And I think that's one quality of a true leader, to empower her people to do a great job by backing off a little bit, but still staying involved with the cases and knowing what's going on within her office. I think one of the other characteristics that I noticed that I don't think I see a lot in executives is Her ability to understand vertical organization, but at the same time develop horizontal relationships, particularly within the community. So in a very structured environment, she was very comfortable, whether she was talking with an executive or all the way down to, let's say, a brick agent or a line police officer, the ability to talk to individuals, make them feel immediately at ease, make them feel that they are actually contributing and that she is listening to what she is talking about and what they are talking about. Likewise, when we talk about the horizontal view across a community, she was very engaged with not just the law enforcement community from local, state, tribal, federal, but also the communities that we were serving. And again, that leadership of leading her office to understand the concerns of these communities was integral to supporting the successes of the offices. So I think she brings a lot of...
Let me ask you about that, because that's about community engagement. So let me ask you about that style. I think that's very important with the U.S. Attorney. I see how important it is in Minnesota. What was her style of engagement in terms of the community?
Very engaged, and someone who was not afraid to engage many different community groups and have very frank discussions about concerns and issues, giving everybody an opportunity to provide input. And that, I think, is incredibly important, because understanding the community you serve is part and parcel of representing the system of justice and making sure that if there are disparities in those communities, if there are issues in those communities, that you understand what they are so that you can help drive change to make the system of justice better in addressing those concerns. With respect to the law enforcement community, she was actively involved in many of the task forces, very supportive of them as a concept that brought departments and agencies, large and small, together to tackle entrenched crime issues, terrorism, and would personally attend executive briefings. And her philosophy was that we were all in this together, that it was incumbent on law enforcement across the board to work shoulder to shoulder to really protect this country and to tackle issues that no one agency could do by themselves. So I personally thought that her leadership skills were outstanding. I viewed her as somebody that I could go to for sound judgment, as a sounding board, and receive sage and reasoned advice in return.
Reverend Newsom,
Yes.
I'm getting the picture of a very impressive leader with those kinds of impressive skills. But you came to testify today, I think, on where that comes from in a moral sense.
Yeah.
Can you speak to where that comes from in terms
Well,
of
I think I can,
compassion
Senator.
and
Thank you, Senator, for the
spiritual?
opportunity. Let me try to be as succinct about this as I possibly can. And Senator Sessions, glad to be reunited with you. We worked on a church burning project some years ago when I was Dean of the Howard School of Divinity, very effectively, thank you. But the word impressive doesn't get it. She is a rare individual. I study people from the standpoint of a religious biographical perspective, so that when you begin to look at what I might call at this point in time the genius of character, you try to sense if it has come down through the generations. I mentioned in my written statement that her grandfather was a Baptist minister, but 3 grandfathers before then. And they served their congregations and their communities with daring, with distinction, and above all, wisdom. And that wisdom was born of a depth of insight into human nature as to how leaders should best behave and be effective in garnering a following and leading them in a way that works for the good of all. Loretta, and I've seen this throughout the years, is the kind of person who can relate transparently enough to inspire trust and confidence, and so that you don't have to work a long time wondering if what you're seeing is truly honest. And this plays its way out in the sense that she's a due diligence kind of person. I understand the hypothetical kinds of issues and questions, but my own background as a scholar would say, well, at best, a hypothetical only approximates a real-life situation. And in a real-life situation, character really comes forth when you do the kind of due diligence that puts you in a position to make the quality of judgments that makes for a positive difference. This is in her bloodline. This is in her spiritual DNA. I don't know if her father is still in the room, but I can tell you that it has played out in the way that he has provided leadership in North Carolina. Whether he had to stand alone or stand with 1,000, it was the truth, the right thing, and the right thing, and character, and character, and character over again. I don't want to trivialize this process by using a sports metaphor, but I am an old, broken-down football player that played at Duke when we were still winning games.
Yeah, that was quite a while.
Quite a while ago. But, you know, we tend to think in terms of a franchise kind of player. She is an exceptional human being, and I cannot avoid the sense of passion I feel right now for the good that would come to our nation in having a person who would be good, absolutely superb, in even healing our nation through the responsible discharge of her duties as the U.S. Attorney General.
So you would be for her being confirmed?
I will be mildly for her, I think.
Although you cheapened it with a sports metaphor, it was a very powerful testimony. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Franken. Senator Sessions.
Thank you for recalling for us that a lot of people we have disagreements with can be wonderful people, and I do sense that about her. And I told her that, well, I was talking to her brother, I believe, but she was raised right. I can tell that. And so sometimes you just get caught up in things. Issues become big, and an individual becomes the focus of the controversy. Sheriff Eastman, thank you for your, not Eastman, Clark, Sheriff Clark. Thank you for your leadership. Now, I had here right in front of me, and I have it now, a piece put out just some time ago saying that there were 36,000 convicted criminal aliens in detention that were released, and that group of people were convicted of crimes such as homicide, sexual assault, kidnapping, and aggravated assault. And I noticed an individual was just arrested for murdering a 21-year-old convenience store clerk in Mesa, Arizona on January 22nd of this year, after having been in ICE custody on a drug and gang-related felony burglary conviction, but was released on bond after a few days. Now, if you release 36,000 people who've been convicted of crimes based on your experience in law enforcement, can't we expect that that group is likely to commit the kind of crimes I just mentioned? Isn't that pretty predictable?
Thank you, Senator. Yes, if for no other reason, because of the recidivist nature of crime, regardless of what demographic is involved with it. I would say releasing 3,600 in the communities that don't have the support structures is, at best, dangerous policy. You know, like I said, they don't have the support structures in place. And then the thing about when we start talking about the criminal aliens, the first thing they're going to do is flee. It's the first thing they're going to do. My experience in working with ICE, we don't enforce immigration law, but we do cooperate with federal agencies in the pursuit of justice like we do any other federal agency. But they come with many aliases, difficult and takes a long time to identify them, but they realize, the individual that's released on bail, they realize that it's in their best interest to flee, and then they turn up in another community. There aren't, I'll just speak to Milwaukee County. We've had those same horde-type stories of individuals who have been brought to ICE's attention, and for whatever reason, they decided not to put a detainer on them or had a detainer and released it. Individuals let out on bail and then goes on to, engage in an even more heinous act. And sure, the easy ones, Senator, are the ones who are involved with murder, sexual assault. Those folks are probably not going to get out on bail. We don't have to worry too much about them. But
Well, as this report indicated, a number of them, like 193 of the 36,000 that were released were homicide convictions. So you're right to assume that serious crimes would be almost unbelievable that they were being released, but data shows that a lot of them are the most serious crimes that are being released.
yeah, I think sometimes some of the reports or some of the rhetoric used in the discussion is on the lenient side. They call them low-level offenders, but some of the stuff that I see that they've been involved with are not literally low-level offenders.
Well, Sheriff, let me just say that you're responsible for protection of people in Milwaukee and that area. And the federal government, the federal statute says someone convicted of a serious felony shall be deported. Doesn't say the ICE has an opinion about this. It says they shall be deported. Does it make your life more difficult? Does it place the people of Milwaukee at greater risk if the officials are not following the law and deporting people who've been convicted of serious crimes?
Sure it does. In my limited knowledge of legal language, shall is not discretionary. So, yeah, I find that problematic when that happens.
And so don't you think it's common sense and just that if a person's in the country illegally and on top of that they commit a serious crime, they should be deported?
Yes, I think it's beyond common sense. I think we have a duty. We have a duty to protect people.
And the law, of course, requires that. And it's just too often not being followed in an effective way.
Senator, may I just add that I
Yes.
think Sheriff Clark has just made one of the strongest arguments in favor of the President's executive actions. The main point of the new prosecutorial priorities is to be able to focus resources on precisely the individuals whom he is describing, and hopefully it will have that effect. I don't know in this case why the state authorities released a person if it was while the person was pending trial. They must have thought that it's safe to release him, so I'm not sure why the onus is shifting to ICE. But that aside, this is what the administration is trying to accomplish.
Well, this isn't a matter of discretion, Mr. Legomsky. I know you served with the USCIS. This part of it is mandatory, is the point I'm raising. We're entering into an utterly lawless system here. Nothing Congress passes, apparently, has the ability to be effectuated in reality. That's the problem. Congress will pass things, and they don't happen. We mandated a fence, 700 miles. Doesn't happen. We said there should be an exit-entry visa, which the 9/11 Commission has hammered us for not completing as law required, and it still hasn't been completed. Are you aware that the group that you worked with, the Federation of Government Employees who represent USCIS, has opposed this bill vigorously?
Yes.
And say it will not work and is not helpful?
Well, this is the very same group whom whom some people are suggesting will refuse to obey the Secretary's instruction to exercise discretion and will instead rubber stamp these cases. So
Well, let me ask you about discretion. That's Professor Eastman, in his testimony before the House on discretion, says there's nothing in the memo to suggest that immigration officials can do anything other than grant deferred action to those meeting the defined eligibility criteria. Indeed, the overpowering tone of the memo is one of woe to line immigration officers who do not act as the memo tells them they should, a point that has been admitted by the Department of Homeland Security officials in testimony before the House. And in the House, the Chairman Goodlatte of the House Judiciary Committee said, quote, DHS has admitted to the Judiciary Committee if an alien applies and meets the DACA eligibility criteria, they will receive deferred action. In reality, the immigration officials do not have discretion to deny DACA applications if the applicants meet these criteria. And I think, Professor Rosencrantz, you indicated there might be an illusory thing here. Isn't that proof that it is illusory discretion? In fact, it's mandatory.
Absolutely.
Well, the memo says precisely the opposite, Senator, with respect. It says that these are cases that, quote, present no other factors that, in the exercise of discretion, make the grant of deferred action inappropriate. And then, and at the very end, there's even more explicit wording. The ultimate judgment as to whether an immigrant is granted deferred action will be determined on a case-by-case basis. So the memo refers explicitly to discretion.
Senator.
Well, we said we're going to do an exit entry visa, and it's not. The truth is that the officials are going to approve the people if it meets the DACA or meets the memorandum standards.
The important thing to notice is that it flips the presumption, right? The presumption is that the law will not be enforced, and somebody might have discretion to enforce the law in a particular case, but this is turning prosecutorial discretion on its head. The presumption in general is that the law will be enforced, and discretion will be used to exempt some, to create an exception to the rule. Here, the enforcement is clearly going to be the exception to the rule if it happens at all.
Except that the entire deferred action memo is the exception, right? The norm is that you do get deported if you fall within one of the deportability grounds. This memo lays out an exception. If you meet the following criteria, then USCIS officials will have the discretion on a case-by-case basis to defer
Well, just briefly, if the people don't meet the standards and somebody does get turned down, well, the projection is a little less than half the people, 5 million out of 11. What if somebody is turned down? Are they going to be deported?
Generally, I would think yes, if they bring their presence to the attention of the enforcement authorities and if it fits within the prosecutorial discretion priorities, then I can't think of any reason that ICE would not go.
They're not going to be deported. They're not. The only ones that are being deported today is, I think you know, are people who commit serious crimes, and we find out even they are not being deported. We reached a lawless stage in the immigration, and the American people are not happy about it. They have a right to demand that their laws be enforced, and the President's actions are some of the most dramatic steps to violate plain law that I've ever seen in my experience. Thank you, Mr. Chairman. My time's over. You're kind.
Thank you, Senator Sessions. As we were preparing for yesterday's hearing, I found a quote I'd like to talk about in a minute for a moment. A quote from a speech given by Ms. Lynch about a year ago in which she made the following statement. It caught my attention because it raises some alarm bells. It says, 50 years after the March on Washington, 50 years after the Civil Rights Movement, we stand in this country at a time when we see people trying to take back so much of what Dr. King fought for. We stand in this country, people try and take over the State House and reverse the goals that have been made in voting in this country. But I'm proud to tell you that the Department of Justice has looked at these laws and looked at what's happening in the Deep South and in my home state of North Carolina, has brought lawsuits against those voting rights changes that seek to limit our ability to stand
up and exercise our rights as citizens," close quote. When I read this, I, for obvious reasons, immediately became concerned. I was wondering what it was that she was talking about, what laws there were out there, what legacy of the civil rights era that was trying to be overturned. Ms. Engelbrecht, can you guess as to what she might have been talking about, referring specifically to her home state of North Carolina?
I can't, and I reviewed the same comments that you referred to, which was, I think, taken from a speech in February out in Los Angeles, and what continues to boggle the mind is that the vast majority of Americans want, understand, and appreciate the need to try to safeguard our elections, and the thought that asking a voter to prove they are who they say they are somehow discriminatory just, you know, it seems to me to be much more about pushing a political agenda than protecting the people.
You know, I wondered about this, so I asked one of my colleagues who's on this committee with me, Senator Tom Tillis from North Carolina, who, as it turns out, at the time she gave this speech, was the Speaker of the House in North Carolina. I asked him what this was about, what she was referring to. These are pretty bold statements, and if someone's going to accuse a state legislative body of moving to undo the legacy of Dr. Martin Luther King, of trying deliberately to diminish voting rights in this country, I feel like we need to know what that is. He suggested to me that it might have been directed toward a law, a voter ID law that was passed by the state of North Carolina at the time that Senator Tillis was the Speaker of the North Carolina House of Representatives. I asked him about this law a little bit, and he told me that when it came forward, there was concern about voter fraud, about the risk of voter fraud in North Carolina. And he said, look, I want to find the most fair statute that there is on the books anywhere in this country, and I want to make it that much fairer. I want to put the belt and the suspenders and another belt and another set of suspenders on it to make sure that no one's voting rights are diminished at all. So they started with the model of an Indiana statute, a model that was itself quite cautious. It continues to allow no excuse absentee voting without an ID. It accommodates individuals with religious objections to photography, providing them with a way, an alternative means of proving their identity. Pays for an ID issued by the Department of Motor Vehicles without any charge to the voter. So they started with that as the model, and then they added a whole bunch of additional protections that neither Indiana nor any other state that's adopted any law like this has had. A 2-year ramp-up period, a special North Carolina program designed to allow homebound individuals to get a photo ID, another government program that not only pays for the government-issued ID, but also allows for documents from a Register of Deeds or the Department of Health and Human Services that can be used to verify ID. Establishes a $1 million trust fund to reach out to those people who might not have IDs. And this list goes on and on and on. This is the most cautious, carefully protective statutory scheme that I can imagine in this area. If, in fact, this was the target of this description, do you think it's fair to describe this legislation that way, as an attempt to undo the gains of the civil rights movement and the gains of Martin Luther King and those who fought with him valiantly to protect voter rights in America?
Absolutely not. I don't think that it's appropriate or fair, and if that's truly the belief that's held, we need to understand what's behind that, because it belies anything that you've just read in making sense.
With your involvement in efforts to prevent voter fraud, what would you say to those who have made the argument that there is no such thing as voter fraud and therefore we need not be concerned about it, and that the only reason somebody could push for it would be because they subjectively want to undermine voting rights? What would your response to that be?
I mean, I think that our history is replete with examples of voter fraud, and I think that it is something that we should take very seriously, because you don't need a whole lot of fraud. You just need a little bit in the right places, and the less that you create a system that secures everyone's vote, the more open it is, obviously, to these kinds of manipulations that just further divide our country in ways that serve no purpose.
Thank you. Sheriff Clark, I wanted to talk to you a minute about the relationship between the Department of Justice and law enforcement right now. How would you describe the relationship between law enforcement and the Department of Justice?
Thank you, Senator. Afraid, I'm not going to engage in hyperbole or exaggerate, but we can't have even a frayed relationship. You know, the mission statement that I cited early on, you know, it talks about partnerships. And just from the Milwaukee experience anyway, we need the help of the U.S. Attorney's Office in the Eastern District of Wisconsin to deal with instances of the violent crime, the repeat offender. We're not talking about the first-time offender. We're not talking about people who may deserve some sort of remedy for some transgression they made. I talked about the 10-year-old Sierra Guyton. Both of those individuals, felons, convicted felons. The prohibition of not being able to be armed or a firearm anyway as a convicted felon means nothing to them. The state has not shown a willingness at the state level. I think it's a legitimate question to ask. What are they doing at the state level with some of these cases? Too much leniency. And I'll tell you one thing, from a deterrence standpoint, Senator, criminals fear the federal system. They just do. And so if we would have, for instance, cases of, it was a very creative, legally, case in Milwaukee where the Jim Santel, the Assistant U.S. Attorney, who we do have a great relationship with, used the Hobbs Act to charge career hold-up men who had gone on a robbery spree, and one of them, I believe, recently received a 15-year sentence, plus they used a firearm in the commission of those crimes. But they don't have to charge all of them. I know they don't have, I've heard about the prosecutorial discretion, but I think if we take this elephant and try to eat it one spoonful at a time, the elephant being the violent crime, it's ravaging all kind of urban centers in America. But if we take the worst offenders and subject them to federal sanctions, that is going to, first of all, ensure you got a better chance at a conviction, and you got a better chance at a more lengthy sentence. For the person who just hasn't cared, if you will, at any state sanctions that have been applied. So that's the sort of help we need from the federal prosecutor's office in Milwaukee. Straw purchases is another one. I won't really wrap the U.S. Attorney's Office for the straw purchases. Law enforcement's really not bringing them to cases. The ones they are dealing with very well. But the armed violent offender is the one I'd like to see go the federal route.
Thank you. Today we've heard from a number of witnesses who have testified both as to Ms. Lynch's qualifications, which are themselves impressive. It's great in particular to see my friend David Barlow. I know of no finer lawyer or human being anywhere than David, so it's always great to see you, and each of you have put a lot of thought into your testimonies. I appreciate both your written testimonies and what you've spoken to us today. The record for this hearing will remain open for 1 week for members to submit written questions for the record. The hearing will be adjourned. Thank you.
Thank you.